Better. Thank you. Good morning. The time is now 10 a.m. and the inquiry is open. Can I first ask that everybody switches their mobile phones off, or at least to silent, please? Can firstly ask representatives of the local planning authority to explain the fire or emergency evacuation procedure, please?
Thank you. We're not expecting a fire alarm test today. In terms of evacuation, if we can just exit through these doors here and follow the officers out into the car parks, please.
Thank you.
Thank you.
My name is David Jones. I'm a Chartered Town Planner and I've been appointed by the Secretary of State to hold this inquiry. The inquiry is into an appeal made by Mr. Hamid Sabahipour under Section 174 of the Town and Country Planning Act 1990 against the decision of North Hertfordshire District Council to issue an enforcement notice in relation to the first and second floor and part of the ground floor of the George at Baldock, 2 Hitchin Street, Baldock, Hertfordshire, SG7 6AE. The enforcement notice, which is dated the 15th of January 2026, alleges, without planning permission, the material change use of the land to self-contained residential flats. The requirements of the notice are 1. To cease the use of the land as self-contained residential flats. 2. Removal kitchenettes, kitchen units, kitchen sink, kitchen wall tiles, cooking hob, microwave oven, fridge and cooking extractor unit. 3. Disconnect the electricity and water utility services that facilitate the kitchenette and cap over to prevent reconnection. And 4. Remove from the land all debris items, building materials resulting from compliance with steps 2 and 3. And the period for compliance given in the notice is 6 months. I shall now take the names of those present who wish to speak. Firstly, for the appellant, please.
Good morning, sir. My name's Simon Bell, counsel, and I'm acting for the appellant today. To my left sits the appellant, Mr. Hamid Sabahipour, and to his left sits our other witness, Nazli Sabahipour. To my right, just for the inquiry's information, is Mr. Sabahipour's son, who is sitting with me.
Thank you. And for the council, please.
Morning, sir. It's Asita Ranatunga here. I'm a barrister and I'm instructed by Legal Services at North Hertfordshire District Council. And to my right, I have Simon Curling, Planning Compliance Officer at the Council, and Christella Menson, Conservation and Planning Enforcement Team Leader at the Council.
Thank you. Is there anybody else present who wishes to speak? Yes, sir, your name.
Hello, I'm Councillor Alistair Willoughby. I'm the Ward Councillor for Baldock West. I would like to speak, please.
So, Councillor Alistair
Willoughby.
Willoughby, thank you. Is anybody from the press present? No, thank you. And does anybody intend to film or record the event?
So just to be clear, sir, the event is being live streamed. And that's what the people in the corner are managing. And I believe that means there will be a recording of it. Yes, I'm told,
Okay.
yes.
Does that present an issue to anybody in the room? No. No. Okay. Thank you. Thank you for that. Just for everybody's information, there is a member of the Planning Inspectorate here today, other than myself, for training and observation purposes. If you see me talking to my colleague at any point later today, please be assured that we won't be discussing the merits of the appeal. Turning now to notification letters. I have copies of the following. Appeal notification letter dated the 27th of March 2026 and a list of recipients. Inquiry notification letter dated the 28th of May 2026 on list of recipients and the site notice. I'm therefore satisfied that the necessary notifications have taken place and we can proceed on that basis. Representations. I have copies of any third representations that have been made in response to the appeal notifications, and I will take those into account when reaching my decision. I held a case management conference call by Microsoft Teams on Friday, the 15th of May 2026, with representatives of both the appellant and the council. It was held to discuss the procedure for today's inquiry, and the merits of the appeal were not discussed. The conference call covered the following matters: confirmation of advocates, the grounds of appeal and likely main issues, how the main issues will be dealt with, confirmation of the inquiry venue and running order, timetable for the submission of documents, and any applications for costs. I have received the proofs of evidence from both main parties' witnesses, so I should expect those to be taken largely as read. Can I just check that parties have had each other's copies of each other's proofs? Thank you. Saying on that theme, all documents and evidence should already have been provided. I do note, I think it was yesterday, there was an email I received from the council, which was emails from the fire officer to the appellant. Has the appellant seen those? Is there any issue with that?
No, sir.
No, thank you. Okay, thank you. Is there any other additional evidence that either party wishes to submit at this stage?
So it's only recently come up in that I've just connected to the Wi-Fi and I've had an email through from the appellant's hotel manager. Before we begin, I'd just like a couple of moments just to have a look at that, because it produces some material that I haven't seen that I just want to double check and speak to my learned friend about. I was just saying that I've had an email that's only just come through that has some material that I need to have a look at and just discuss briefly with my learned friend. It won't take very long. I think it'll take about 5 minutes.
Ms. Van Tonga, any issue,
Yes,
any issue with that?
of course. Can I just tidy up on the fire safety emails, though? Yes, they were submitted yesterday. I'm grateful there's no objection to those. It was 3 emails between Sam Priest, and you'll have seen his statement, and it really is supporting emails to that statement between him and the appellant or the appellant's representatives. We have marked that NHC 41A, NHC 41A as those 3 emails. So just for your note.
Thank you. Mr. Bell, when would you like, or when's most convenient to have a look at that email?
It's probably just before openings, I would have thought. So if third parties want to speak, or if Councillor Willoughby is planning to speak, then if we do that first, we can get started.
Yeah, okay, so you'd like a short adjournment before openings? Yeah.
Yes, please, sir.
So any objection, Mr. Van Tonga? No, that's fine with me. Okay, that's no problem. Thank you, Mr. Bell. Just sticking with the evidence briefly. While we're talking about the evidence, as both parties will be aware, the council have referred to a video of a previous planning committee in their evidence, which was forwarded obviously in advance of today, and a transcript of that. The council proposed that that's dealt with in chief and cross-examination. So, Mr. Bell, is there any concern or issue with that proposal?
No, none whatsoever. I mean, we still query as to why it needs playing if there's a transcript of it, but we don't object to it.
Well, I think that's the point. I think if you're happy, I don't think I'm satisfied that there's no need to play the entire video.
I'm grateful, sir. As long as you've had an opportunity to look at it,
I have,
as the appellant, I'm sure, then we don't need to have it played. There is a transcript that goes with it, and
Yes,
I
I've
will
seen
make
that.
reference to that.
Yes. Okay. Brilliant. Okay. Thank you. I'm mindful that some parties here today may not be familiar with the procedure of an inquiry, so I will just briefly outline them for their benefit. This will just take a couple of minutes. When I've concluded my opening remarks and following a short adjournment, as we just heard, I will then first ask the appellant's advocate to introduce their case in an opening statement, which will be followed by the council's opening statement. Any interested parties who wish to speak will then be invited to provide their evidence, subject to any examination by the main party's advocates. I will then ask the appellant's advocate to present their case and evidence first, and each witness shall be heard in turn as follows. The council's examination chief by the appellant's advocate, the council's opposing advocate, will then have an opportunity to cross-examine the witness. There will be an opportunity for questions from any opposing interested parties, and I may also have some questions. And then the appellant's advocate may then put some questions in re-examination to the witness. I will then ask the counsel to present their evidence in the same way. And as I've already set out, I will generally ask any questions that I have during evidence in chief or before re-examination. Just for the benefit of parties in the room, it was agreed at the case management conference that I shall hear closing submissions from both parties virtually online this coming Thursday, which is the 25th of June at 11 a.m. That is to ensure that obviously good timekeeping and that we can hear all the witness evidence today and then carry out a site visit this afternoon. The council will provide a link for that for any interested parties to view those closing submissions online on Thursday, should anybody wish to view them. So therefore, upon hearing all of the evidence from the main parties today, I shall then make an accompanied site visit, which is currently envisaged to be at some point later this afternoon. The site visit will be solely for me to see the site and surroundings, and there will be no discussion about the case at that visit. Are there any comments on that running order? No, thank you. May I request that advocates remain seated at all time during the proceedings? And should we please note the position of the witness table, which is 1 minute there to my left in that corner over there. That is where I shall hear all the various evidence and the witnesses at the relevant time. Because in this case there's clearly a dispute on fact of legal grounds, then I propose that the evidence, all evidence, should be taken on oath or affirmation. The sanction behind the administration of an oath or affirmation is provided by the Perjury Act 1911. This states that any person lawfully sworn as a witness in a judicial proceeding willfully makes a statement material in that proceeding which he knows to be false or does not believe to be true, he shall be guilty of perjury. 7 years imprisonment is the maximum penalty for perjury in a judicial proceeding, which includes a proceeding before any court, tribunal, or person having by law the power to hear, receive, and examine evidence on oath. The other potential sanction is that a decision may be overturned in the High Court if it is subsequently found to have been based upon false or misleading evidence that was given at the inquiry. As well as statutory parties, third parties who are giving factual evidence will also be sworn. Can I remind advocates that they should not communicate with their witnesses, including the lay client, outside of the inquiry once cross-examination of that person has commenced, unless they need to clarify some technical issue and I consent. I shall now move on to time estimates. As I hope we all know, the inquiry is currently, was scheduled for 1 day, of course, with the virtual closings on Thursday, as I've already set out. So I've attempted to establish a programme to ensure today runs as efficiently as possible. I have received estimated timings from the main parties. So I will hope that after my opening and obviously both parties' opening statements, I would aim to hear from both the appellant's witnesses, ideally before we break for lunch. In an ideal world, going off the estimates, I would estimate lunch to be about 1:15, 1:30. Then after a short lunch break, we would then, of course, hear the council's two witnesses. And then at that point, we would break for the site visit, and that would conclude today before we reconvene online on Thursday morning. Of course, I can review, obviously, as we progress through the day. However, do the parties have any proposed concerns with that timetable at this stage? Mr. Ranatunga.
So no, can I just check this though? I think you did ask for hard copies of all the papers, and I think, do you have those?
Well, I've got three ring binders here, which
you.
it looks like it.
I'm just wondering if there's one for the witness. No, to the extent there isn't, the only thing about time estimates is if we're looking on our laptops for documents, that can take longer or it may not. So,
well, I'm happy if the witness hasn't got them. It might be more beneficial for them to have these copies than myself, because I have actually brought, and I've got everything.
I'm grateful.
Is that,
yeah. If that speeds things along, that
I'm sure it will. Yeah. Mr. Bell.
I mean, so just to be clear, we've got a copy here as well, which I think is probably for the witness, so that can go in there, and then you've still got your copy.
Okay. Yeah. Okay. That's great. Thank you. As I said, hopefully we'll aim to break for lunch somewhere between 1 o'clock and 1:30, with a short break in the morning, and if necessary, the afternoon. I will seek the assistance of the advocates in finding suitable times to break. In order to meet the timetable and to make best use of the time, can I request the following, please? From advocates, I want direct and relevant questioning and cross-examination that is focused on the main issues and getting the evidence that I need to determine the appeal. And from the witnesses, can I have direct answers to those questions that also focus on the main issues? There is no need for witnesses or advocates to read out the proofs of evidence because I've already, of course, received those and read them in advance of today. The appeal has been submitted on the following ground, which is ground D, which is at the date the notice was issued, no enforcement action could be taken in respect of any breach of planning control, which may be constituted by those matters. The main issues, therefore, as I see them, are in respect of ground D. One, whether on the balance of probabilities, the property was physically converted into self-contained flats and each unit was occupied and used as a dwelling house for a period of at least 4 years prior to the issue of the enforcement notice. And secondly, whether the development has been or had been deliberately concealed. Is there any comments on those main issues? No, thank you. That concludes my opening remarks. Are there any queries about the procedure or any other matters before we have a short adjournment? Nope. Okay, in that case, the time is 10:15. Would you like, Mr. Bell, how long?
So yes, please, 5 minutes.
5 minutes. Okay, so we'll reconvene at 10:20. Thank you. Here the time is 22 minutes past 10 and the inquiry is resumed. Mr. Bell.
So, sir, just to explain, as I mentioned earlier, I've been sent an email by the appellant's hotel manager, who has sent me over some of the tenancy agreements with signatures on them. Mr. Curling, at his proof of evidence at paragraph 3.9, references 8 of the tenancy agreements not being signed. I haven't been able to download them all. I have to say they've been sent to me in a Google Drive and I've been trying to download them, so I'm looking to get them as attachments. I've shared a copy of the Google Drive and one of the tenancy agreements with my learned friend. I understand that he will be taking a point that they shouldn't be admitted at this late stage, and I do understand that. But given it's just been provided to me and I haven't had a full opportunity to look at them, it seemed necessary to raise it to the inquiry's attention at this stage.
Well, my first question, which is a fairly obvious one, is why have these only been provided at 10 on the morning of the inquiry? Because clearly the appellant presumably would have had these in their possession long before this morning.
Sir, I do appreciate that. As I understand it, there was a search undertaken yesterday for them, and they have now been identified this morning. I understand the unsigned versions were sent over in error. I do appreciate that's an error that should have been corrected a while ago. But sir, they are here. The only element of the case that they obviously change for my learned friend is that they are on the face of it signed agreements. He can make the points he wants to make about those, and there are still 2, it looks like, that are unsigned. So there isn't, in our submission, any prejudice that comes from the late submission of them today. But sir, I do appreciate that it's unacceptable that it's so late in the day, but the explanation is they've only just been found.
Mr. Ranatunga.
So I do object to those going in. This is a ground D appeal where the burden is squarely on the appellant to demonstrate immunity, and the inquiry has a process to deal with that, which is underlined by fairness. And 4 weeks ago, we had exchange of evidence, and Mr. Curling conscientiously looked at the documents that were already in and made comments on them. For your note, sir, paragraph 3.9 refers to tenancy agreements which are undated. Paragraph 3.11 of Mr. Curling's proof deals with tenancy agreements which are unsigned. So there's 2 different points. To receive them now, I mean, within the last 5 minutes, is unacceptable. We will look at them, but I am objecting to them going in at this stage. There's no good explanation why they couldn't have come in at any point within the last 4 weeks.
Thank you. I mean, I think on balance, I'm inclined to not accept them on the basis that there's been ample time. We've had, as we mentioned, the case management conference. The proofs were submitted 3 or 4 weeks ago, whenever the deadline was. I find it hard to believe that they have either only been found at 10 o'clock this morning or could not have been found at some point earlier. As you've already said that, Mr. Bell, in any event, it sounds like there would still be 2 tenancy agreements that are unsigned, so it doesn't ultimately change the entirety of the point in terms of unsigned agreements in any case. But the fundamental issue I have is in terms of the procedure and the fairness and the explanation given as to why they've only surfaced after the opening of the inquiry. Unfortunately, I don't feel satisfies my adequate reason why for them to be submitted at this late stage. So unfortunately, I'm not going to accept that late evidence at this stage, Mr. Bell. Right. With that in mind, we shall now hear the opening statements, please.
Thank you, sir. I have copies in writing, one for you and one for my learned friends. So, sir, these short submissions are made by way of opening on behalf of Mr. Hamid Sabahipour, the appellant. This appeal concerns an enforcement notice issued by North Hertfordshire Council on the 15th of January 2026, alleging the material change of use of part of the George at Baldock from its lawful hotel use to self-contained residential flats. The appeal is brought solely on ground D, namely that at the date when the notice was issued, the time for taking enforcement action had expired. The issues for the inquiry are relatively narrow and have been helpfully identified in the Statement of Common Ground. In essence, you are being asked to determine whether the appellant has demonstrated, on the balance of probabilities, that the units the subject of the notice had been in continuous use as self-contained flats throughout the relevant immunity period of 4 years, and whether the council is correct to contend that any immunity otherwise available is displaced by reason of deliberate concealment. Turning to the matters agreed. It is important to begin with what is no longer in dispute. The parties have agreed that the use alleged in the enforcement notice has occurred and amounts to material change of use to self-contained flats. The parties have also agreed that all units comprised within the appeal site on the first and second floors are self-contained flats. This inquiry is therefore not concerned with determining whether accommodation is capable of amounting to self-contained flats. That issue has effectively fallen away. The remaining dispute concerns continuity and concealment. It is also important to be clear about the appellant's position in relation to the scope of the appeal. The appellant does not contend that all of the matters alleged in the enforcement notice are immune for enforcement. As set out in the Statement of Common Ground, it is accepted that part of the development, namely 4 ground floor units, do not benefit from immunity and are therefore unlawful. The appeal is therefore concerned with establishing the lawfulness of 17 units that comprise the first and second floors. Turning to the legal framework briefly. The appellant accepts that the burden of proof rests upon him. The applicable test is well established. The question is whether the evidence relied upon is sufficiently precise and unambiguous to establish the claim lawful use on the balance of probabilities, and that's the case of Gabitas. The appellant likewise accepts the legal principles concerning deliberate concealment. In Welling Hatfield, the Supreme Court held that a person may not rely upon the statutory immunity provisions where there has been a positive deception in matters integral to the planning process. Lord Mance described the relevant conduct as positive deception in matters integral to the planning process, directly intended to and did undermine the regular operation of that process. The appellant accepts that principle. The appellant further accepts the principle that survives the introduction of the planning enforcement order regime, as confirmed by the Court of Appeal in Jackson and Bonsall. The appellant also accepts that there is no separate requirement that conduct be exceptional or egregious before the principle can apply, and that physical concealment is not a necessary ingredient in every case. That's Matilda Holdings. The legal principles are therefore largely common ground. The real dispute is factual. Turning to the appellant's case. The appellant's case is straightforward. The evidence will demonstrate that the first and second floor units became physically self-contained during 2021 following the installation of kitchenettes, the last of which was installed in November 2021. The evidence filed to date demonstrates continuous occupation thereafter through a substantial body of documentary and witness evidence, including tenancy agreements, occupation records, bank statements, contractual records, statutory declarations, and you will hear oral evidence. The notice was served on the 15th of January 2026. The appellant's case is that the material change of use relied upon by the council had therefore occurred more than 4 years before the service of the notice and had continued without significant interruption throughout the relevant period. It is on that basis the appellant contends that the 17 units found on the first and second floors are lawful due to the passage of time. Turning to concealment, the council's alternative case is that the appellant should be prevented from relying upon any immunity because there has been deliberate concealment. The appellant's position is that the evidence does not support that allegation. The appellant accepts the legal principles discussed earlier. The issue for this inquiry is not the applicable legal test, but whether on the particular facts of this case, the council has established positive deception in matters integral to the planning process. The appellant's case is that it has not. The appellant's case is that the factual circumstances relied upon by the council are far removed from the authorities upon which it relies. In particular, there is no suggestion that the physical layout of the building was hidden from the council, that the council was prevented from inspecting the property, or that occupiers were concealed from the authority. On the contrary, the evidence to date shows the council investigated the same substantially alleged use in 2022. That investigation was closed with no breach having been established. The LPA then undertook further investigations in 2025, carried out site visits, obtained information regarding occupation, and was provided with extensive documentation concerning the operation of the property. The evidence also shows that the appellant understood that operation at the time. How the appellant understood that operation at the time. The accommodation was consistently described as hotel apartments or serviced accommodation, reflecting what was understood to be a managed long-stay hotel model. That description was not an attempt to disguise the underlying facts which were disclosed, but a genuine characterisation of those facts at the time, including reliance on professional advice. The appellant only came to accept the council's alternative characterisation of those same facts as self-contained flats once the position was taken by the authority. The dispute which has emerged is not a dispute about hidden facts. It is a dispute about how known facts should properly be characterised in planning terms. The appellant's position is that a disagreement as to planning characterisation is not, in law, the same thing as positive deception. Whether the council ultimately agrees with the appellant's previous description of the use as hotel apartments or serviced accommodation is a different question from whether the appellant deliberately concealed the true facts from the authority. The appellant's case is that he did not. Turning to evidence, the inquiry will hear evidence from the appellant and Nazli Sabahipour. Through those witnesses, you will hear evidence concerning the installation of the kitchenettes, the operation of the accommodation from 2021 onwards, the continuity of occupation, the information provided to the council throughout its investigations, and the circumstances giving rise to the council's allegation of concealment. At the conclusion of the evidence, you will be invited to find that the material change of use relied upon by the council had occurred by November 2021, that the change of use had existed continuously throughout the relevant immunity period before service of the notice on 15th of January 2026, that the council has not established the positive deception required to engage the principle found in Welling, and that the enforcement notice should therefore be varied so as to exclude those lawful units, with enforcement action remaining only in respect to those parts of the development which the appellant accepts are not immune. The appeal should therefore be allowed in respect of the 17 units.
Thank you, Mr. Bell. Mr. Ranatunga, the council's opening, please.
Thank you, sir. This is the council's opening, and I think you've got a copy and Mr. Bell has a copy, and there's a couple that we've handed out at the back. In this appeal, North Hertfordshire District Council defends an appeal against its enforcement notice issued on the 15th of January of this year relating to the George, which once was a traditional hotel in the heart of Baldock. The appeal is made by its current owner, Underground D, namely that at the time the enforcement notice was issued, it was too late to take enforcement action against the matters stated in the enforcement notice. The enforcement notice stated that the breach of planning control appeared to be, without planning permission, the material change of use of the land to self-contained residential flats. The reasons for issuing the enforcement notice included adverse effects on the character of the area, it's in a conservation area. Loss of hotel provision with a consequential effect on tourism and visitors to the area. Inadequate living conditions for the occupiers against the council's space standards, and inadequate parking provision. Whilst you will see for yourself on your site view, it will be apparent to anyone who actually sees inside the first and second floor rooms that they are cramped and provide inadequate space with a congested layout for self-contained residential flats. The enforcement notice related to the first and second floor, as well as part of the ground floor of the George. The starting point in this appeal is that the appellant has not appealed against the change of use of part of the ground floor. It's a partial appeal relating to 17 rooms on the first and second floor only. As a result, the enforcement notice will be upheld relating to the ground floor in any event. The immediate context of the ground floor use is that in January 2024, the appellant applied for a part change of use and conversion of the ground floor to, amongst other things, 4 hotel rooms, C1 use. Permission was granted on the 21st of June 2024 following a planning committee meeting, which was recorded and has been submitted as part of the council's documents. A series of questions were asked by councillors directed at the current and proposed use of the site. They were assured by the appellant's planning consultant that the current overall use of the building was a hotel and restaurant, and that the new rooms would add to the existing hotel use. They were not bedsits by the back door. Remarkably, given those assurances, the appellant has not appealed against the allegation that the ground floor units have changed to self-contained residential flats. He also now refers to 17 studio flats on the first and second floors, the very bedsits the councillors were concerned about and wrongly assured of. The circumstances are at the time rightly led officers at the council to revisit and investigate the use of the building and whether there had been an unauthorised change of use. The new investigation led to the conclusion that there had been a change of use to self-contained residential flats, and documents provided in response to a planning contravention notice in December 2025 did not match with responses given previously. They confirmed officers' concerns and triggered the issue of the enforcement notice. Despite consistently stating with the benefit of planning expertise that these were hotel apartments as part of a hotel use, the appellant has jettisoned that argument when issued with an enforcement notice. Instead, it's argued that their use as self-contained residential flats is now immune from enforcement action because it's continued for 4 years prior to the issue of the enforcement notice. The position is surprising, to say the least. It relies on an argument that the underlying facts have remained the same and that it is just the characterisation of them in planning terms which has changed. The council will contend that that argument simply does not stack up when the documents and evidence are scrutinised and weighed up. It's against that background that the Ground D appeal should be considered, and for the purposes of opening, I make a few brief points. The burden of demonstrating on the balance of probabilities that the use of the 17 rooms has been as self-contained residential flats falls squarely on the appellant. Against that test, the council does not have to prove anything. The council has put forward evidence in its statement of case and that of Simon Curling, who's the planning and compliance officer, which shows that the appellant's case is not sufficiently precise and unambiguous to discharge the burden of proof. It's up to the appellant how he seeks to demonstrate that case, with what documentary and what oral evidence, so as to satisfy this tribunal. In that regard, so we endorse your unpacking of the Ground D appeal in your first main issue. Whether on the balance of probabilities the property was physically converted into self-contained flats and each unit was occupied and used as a dwelling house for a period of at least 4 years prior to the issue of the enforcement notice. Further, or alternatively, through the evidence of Christella Menson, she's the planning enforcement team leader, the council contends that when considered as a whole, it contains information which was incorrect, information not disclosed and or withheld, and includes positive acts and omissions, which together amount to deliberate concealment of the change of use to self-contained residential flats when assessed against the 4 tests in Welwyn Hatfield. There's been positive deception, an undermining of the process of upholding planning control, an actual impact and profit from wrongdoing. The use of the word hotel, whether or not associated with apartments or similar, is in common parlance and widely understood, especially for those, such as the appellant, who have considerable experience in the hospitality industry. Use as self-contained residential flats is not synonymous with use as hotel apartments, and the two cannot be used interchangeably. The appellant's change in position reveals the concealment which has taken place. No one should be allowed to profit from their own wrongdoing, and the effect should be that the period of deliberate concealment should be disqualified from the immunity period. That addresses your second main issue. For those reasons, so we will in due course invite you to dismiss the appeal and uphold the enforcement notice.
Thank you, Mr. Ranatunga. Okay, now is when we're due to hear from any interested parties. Councillor Willoughby, you've obviously said you wish to speak. Are you just quickly? Are you giving what you consider to be matters of fact, evidence relating to matters of fact? And are you in support or against the appeal? Just for my, okay, yeah, it's okay. Are you happy to be questioned by the parties? Okay, and are you happy to give you evidence on oath for affirmation? Yeah, okay, thank you. Repeat after me. I, followed by your name, full name.
I, Alistair Willoughby,
Do solemnly,
sincerely,
truly declare,
and truly declare
and affirm that the evidence I shall give
and affirm that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you. When you're ready, Mr. Councillor Willoughby.
Thank you. I'm speaking today as a local councillor for my community and on behalf of the community in Baldock. I believe the matter before you is simple. There has been a material change of use at the George carried out without planning permission, and the appellant, Mr. Sahabapour, has not demonstrated any lawful basis for that change. I believe there is an inconsistency in their own evidence, and I want to draw attention to something fundamental. The appellant's own statements and that of their agent at the planning committee in June 2024 contradict each other. In particular, I think you'll obviously question this evidence later on, but when I raised in that planning committee on the 21st of June 2024 that I had had conversations with the appellant and I was told that these units were used for a longer term stay. I appreciate that there is no formal recording of this conversation as it was during at the time within the George building when Mr. Sabahapour gave me a tour along with Nazali. In his statement, his agent at that committee and in his answers to the questions from the committee members told us that this was not the case and they were for normal hotel room use, not bed sits by the back door, as has been said. Now, in this appeal, they claim the building has been used as flats for more than 4 years. And both statements cannot be true. And I think this goes towards directly towards the credibility of the evidence being put forward by the appellant. Across the applications, across committee discussions, and now this appeal, the information provided by the appellant or agent has been inconsistent, contradictory, and changed whenever it appears to be convenient to do so. Whether that is deliberate or careless, the effect is the same. The council and the public were misled, and the inspector should treat the appellant's evidence with caution. And the reality is the George was a hotel and has been a hotel. There has been a hotel on that site for hundreds of years. It is a long-standing use of that site. The shift to long-term residential occupation is recent and it is clearly unauthorized. There is no reliable evidence of continuous use of self-contained flats for 4 years that have been provided, in my view. There is no contemporaneous documentation, I do not believe, to support that claim that it has been more than 4 years. And there is clear evidence that the applicant themselves described the room as hotel rooms only, and as did their agent just 2 years ago. Beyond that, the accommodation is not suitable for long-term living. And I don't, as a representative for Baldock, I do not believe that anyone in Baldock should be living in substandard, inappropriate accommodation, as I believe this is. I know that's not the question specifically today, but it speaks to why, had they put in for a change of use to residential use, I do not believe that that would have been granted based on the standards set out in the National Planning Policy Framework, or indeed the council's own policies in planning. These rooms were designed for short stays. They do not provide the space, facilities, or amenity required for long-term occupation. And I will say that I believe allowing this appeal would effectively endorse the creation of poor quality, unregulated housing in the centre of our town, which I do not believe is acceptable. And I believe there is an impact on the town. The George is a landmark building, as I say, its proper use actually does matter to the residents of Baldock. And I believe the unauthorised conversion removes valuable visitor accommodation, undermines the vitality of our town centre, and introduces residential use in a way that is poorly planned and poorly executed. And I believe it sets out a dangerous precedent that someone could get away with the change of a use of a building first and only seek permission or claim immunity when enforcement catches up. I believe the council's enforcement action is justified. I believe it's proportionate. I believe it is necessary. I believe the appellant's case is weakened by their own contradictory statements, and their failure to demonstrate lawful use in the unacceptable standard of accommodation created without permission is unacceptable. For these reasons, I respectfully ask you to dismiss the appeal and uphold the enforcement notice in full. Thank you.
Thank you, Councillor Willoughby. Mr. Bell, do you have any questions?
So I just have a couple of questions to ask. The first one, you referenced an unrecorded conversation with the appellant about it being used as for long-term stays. What did you understand long-term stay to mean?
At the time, I was told approximately a month, which would suggest, in my view, a long-term hotel use.
Thank you. And that was in 2024.
That was in 2020. Yes, I believe that's 2020 or late 2023. Apologies, because obviously when the application went in.
Now, you referenced the fact that George had been a hotel for hundreds of years.
Sorry, to give a slight correction, if I may, there has been a hotel use on that site, or an inn use on that site for hundreds of years, not necessarily that building in particular.
Do you know what the use of the site was before the appellant took on ownership?
Various uses of hospitality.
Hospitality, what do you mean by that?
Pub, restaurant, that type of thing.
You're speaking today as a ward councillor. Can I just ask a general question? In terms of the speech that you've read out, did you show a draft of that to the council's officers at all before coming today?
I did, but only to notify them that I was putting that forward.
You didn't ask for any comments on it?
I only provided them the notes. No,
they didn't provide any.
They didn't provide any comment.
Thank you, sir. I don't have any more questions.
Thank you, Mr. Bell. Mr. Ranatunga, any questions? No. Thank you, Councillor Willoughby. Thank you. Okay, we'll now hear the appellant's evidence. Can I ask Mr. Bell to introduce your first witness, please?
So, sir, my first witness is the appellant, Mr. Hamid Sabipur. He's going to make his way over there now.
Happy to take the affirmation. Please repeat after me. I, followed by your full name,
I, Hamid Reza Sabaipur,
do solemnly,
do solemnly,
sincerely,
sincerely,
and truly declare
and truly declare
and affirm
and
that
affirm
the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
nothing but the truth.
Thank you.
So help me
Please
God.
proceed.
Thank you.
Mr. Bell, when you're ready.
Thank you, Mr. Sabaipur. If you want to pull the microphone towards you,
I use this one.
yes,
Can you hear me?
I can. So, Mr. Sabaipur, before you start, I just want to explain. I'm going to be asking you only a few questions because you have given written evidence in the form of your proof of evidence, which the inspector has read. You've also given a statutory declaration, which appears at core document 3.7, and also a written statement that was given in lieu of an interview under caution, which is in core document 4 with the sub-reference NHC 13R. Now, when I ask you questions, keep an eye on the inspector's fingers if he's typing. If he looks like he's struggling to keep up, just slow your answers
I'll do
down.
that.
And the same goes with my learned friend, whom I suspect when you're questioned by him, you may be inclined to go a bit more faster. But the important thing is that the inspector is able to hear and makes a note of your answers.
Okay.
So, Mr. Sabaipur, just could you explain what your role is in relation to the Georgia Bulldog?
I'm the owner of the Georgia Bulldog.
And how long have you owned it for?
We bought it in 1997.
And what was it prior to your purchase?
As the Councillor Willoughby said, it was all sorts of things before my purchase, but it was closed when I bought it. It was closed for a long time. And during my time in Bulldog, which I say for in excess of 45 years, I've seen the heyday of the George. George was a Hubble Bulldog, but since it has been chopped about, it was turned into residential, and I'm secured the front part, which I turned it into hotel and restaurant.
Thank you. So you've said it's been various uses and it was closed. Prior to it being a hotel, what was it?
But to be very frank with you, I mean, I think I have a better knowledge of the George because I was always interested in the George because it was a building which I always wanted to be part of. And much to my dismay, most of the time since in its heyday when it was the Georgian Dragon, again, when I came to Bulldog, it was the Georgian Dragon. It was a Bernie Inn steakhouse. I mean, it's probably some of you guys are not old enough to remember Bernie Inns, but Bernie Inn was the steakhouse, and it was a very thriving Bernie Inn, and as a whole, it was. But since the management changed, which he worked closely with me, and I was the manager of Zeus Greek Restaurant at the time in 1981-82. I was running that for, still own the place. We had very close relationship together with me and the management of the George. And it was, as the councillor said, it was a Hubble Bulldog. Yeah, it was. But I bought it and I turned in 97 part of the front part of the George, and I turned it into hotel and restaurant. But prior to my ownership, it was a gem. I don't know whether any of you remember it. It was closed for most of the time. It was up for sale. There's a restricted covenant on the George that makes it difficult for people to come around and operate it. But I was, I liked it so much, and I took the George and I made it what it is and what it was prior to COVID.
Okay.
Can I have some water, please? Thank you very much. Yeah, thank you.
So you were just explaining the use prior to COVID, which brings us into the era that the inspector is most interested in.
Yes.
So can you please just explain briefly, what was the business model that you were operating just before COVID?
It was a hotel and restaurant. My business model is hotel and restaurant. I've got a couple of those at in other parts of Baldock, but COVID was what affected our business mostly. It was not only COVID. We had other issues such as local budget hotels that were affecting us, but the COVID was the one that he closed our establishment.
So having had the establishment closed, what did you decide to do in terms of your business model?
But the government was coming up with various ideas of how to operate a restaurant. This was difficult. It was really unworkable. And how to run a hotel. Of course, it took a long time. I'm sure if you remember during COVID, there was serious relaxation. But then again, running a hotel, especially with small numbers of hotel rooms, was not viable for us to do it as a one-nighter, as it was prior to COVID.
So I think at paragraph 4.2 of your proof of evidence, you describe looking for alternative ways to make the business sustainable.
Yes.
And that you identified an opportunity to adapt the rooms for longer term stays by installing kitchenettes.
It was a great shame to leave them idle. I'm sure the inspector is welcome to have a look at it. It is, I put my heart and soul into turning that place into what it was and what it is. It's a very, very nice hotel that Baldock should be proud of. But having said that, it was sitting doing nothing because we simply was not financially viable for us to basically use it as a one-nighter because of, if you remember those days, if anybody sneezed, anybody coughed, you touched anything, and you couldn't handshake, all of those things made the matter worse for us to effectively use those and give confidence to the second person who was coming to the room to stay in that room with confidence. So as a result, we came up with this, and we saw other examples locally in Welwyn Garden City that was effective, and we turned to that.
If I pause you there, now you exploring other examples. Now, if I can turn you to your statutory declaration, which is core document 3.7. Now, it should be in one of the bundles in front of you. You should be able to find a tab that says 3.7. So would it be okay if I identified, because I don't have the hard copy bundle, if I go and...
Yeah, that's fine, yeah.
Yes.
So here, at paragraphs 3 and 4, you describe, first of all, alternative ways to make the business sustainable for longer term stays.
Yes.
And then at paragraph 4, you describe that the approach that you were taking by installing kitchenettes within the bedrooms was informed by similar models adopted by other hotels.
Yes, the nearest one to me was the Best Western in Welwyn Garden City, which I visited with my wife, and it was working in the same under the same condition and during the same time.
And so, what were the facilities there?
The same as what I put in my the hotel rooms in the George. It was a sink, it was a microwave, and it was a fridge, and a hub, and also a ventilation as we installed it. We came up with a more compact version of those things by searching the market, and Elfin Kitchen, they were offering a German make, 1 meter compact with everything in it. So we managed to get one of those well built, and we use those.
Thank you. In respect of how you set up letting the rooms in terms of the agreements to let the rooms, how was that informed?
But again, I'm not running the day-to-day running of the hotel. I think is my daughter is better placed to answer your question there. But again, this was longer stay. We came up with an idea, as I explained why, because of the COVID and the restriction the COVID brought with itself. And we adapted a long stay, and I asked my daughter to explain in detail because she was the operation manager and she was running it day to day.
Now, you will have seen from the council's evidence and their submissions that there is a lot of criticism aimed at your use of the terms hotel, hotel apartment, long-term stay, that type of thing. What was your understanding of the operation of the George Hotel up until the point that the enforcement notice was issued?
I need to repeat what I said in my evidence, that from February 21, we operated long stay, and we were, when we were asked the first time, we mentioned it to the council, and we told them we are a long stay and we have kitchenette for our business guests. Prior to the COVID, we had people that they were staying with us on a long-term basis too. It was not as if it was a shock to our system, or we were offering much the same to those that they were staying with us on a much reasonable terms. Of course, we needed a bit of give and take. We needed to accept that we will give them for a long stay for a month or more, or to commit themselves to us that for a long stay.
We're here dealing with an appeal in relation to the use as flats. Why do you say that these are in use as flats now?
Mr. Bell, the terminology or the classification of the flats, which has recently, as recent of November 25, has been told us by, we've been calling them hotel apartment. I still like to call them hotel apartment. The council's finding is they are flats, and based on the advice of my planning officer, we sided with the council by calling them flats. But the running of the our operation was always long stay with the kitchenette, and we mentioned it and it in my letter of 22. I think it was April 22 that I responded to the council, and I did say all of these to the council, that we are a hotel on a long stay. Whether the terminology or the classification of the hotel apartment changed to flats, we've been advised to accept that.
You will have heard criticism, and you would have seen criticism, and it will be put to you shortly, I suspect, that based on your experience as a businessman and dealing with buildings such as this, you would know the difference between a hotel and flats. Do you know the difference between a hotel and flats?
But Mr. Bell, we've got our learned friends here that their finding, when I was reading them, comes to a great similarity between a hotel and flats. And so I'm not qualified to say whether they are flats or they are hotel apartments. The classification is for the matter that it needs to be considered by the inspector or the council. But I was running it as a long stay, openly, with kitchenette for our business clients.
What is your response to the allegation that you've misled or
Well,
deliberately concealed?
This is the hardest one on me. I have been in Bulldog for over 45 years. I have done a lot of applications with the council, and I have never ever been treated the way that this inquiry has put before me, ever. I've always had a great relationship with the council. It is not in my interest, because I've got too much in Bulldog, too much in the stake to basically to say anything other than what we were running. We were open from day one, and we were running it on a long stay since February and until now. So I can assure you it is not an easy one for me to take, that I have been misleading the council.
Do you want the George to be considered to be flats?
Well, whatever that the outcome of this inquiry classifies it, we are running it as a long stay hotel apartment, and if the council wishes to classify it as a flat, that my planning advisor advises me to accept, I'm at your mercy.
Sir, I don't have any further questions for the appellant. So.
Thank you, Mr. Bell. Mr. Sabahipur, Mr. Ranatunga will now have some questions for you.
Sure.
Mr. Sabahipur, can I just check? You have hard documents in front of you, which have got, I believe, the core documents and your statement and your statutory declaration. We are going to go to some of them. All right.
You need to bear with me to find them, sir.
Yes. So there might be pauses whilst that happens. All right. But we will be going to those. Can I just check? You've got 3 folders. So that covers all of them, does it? Okay. I'm seeing that's yes. Can we start, please, by just understanding this? You have over 40 years experience in the hospitality sector, yes?
Yes.
And that includes hotels, doesn't it?
It does.
Yeah. And I'm assuming that the George was not your first hotel.
No.
And you do, I mean, you've mentioned not being qualified to speak to what a hotel is, all right? But we can agree, can't we? I mean, even without your experience, your vast experience, we can agree a working definition of a hotel, can't we? If I said to you, a commercial establishment that provides paid short-term lodging, that's what most people would say is a hotel.
I agree with you.
Paid lodging on a short-term basis usually provides meals. A hotel usually provides meals.
Not necessarily. You go to these service hotels that they don't provide meals.
Okay. All right. Well, that's helpful. And they are not, are they, self-contained dwellings? Are they hotels? It's just, you know, let's not talk about the legal niceties, planning, who's qualified, who's not. Hotels are not self-contained dwellings, are they?
Hotels are not self-dwelling.
They're not self-contained dwellings, are they? You wouldn't look at a hotel and say, oh, that's a self-contained dwelling, would
No,
you?
I agree with you.
And often hotels have travellers, don't you? That's why they're short-term lodgings.
Yeah.
They're not someone's home where they live, yes? They are places often where people stay for 1 day, 2 days, a short term.
We had mixture. How do I respond to you, sir?
Well, try answering the question. It's normal, isn't it, for hotels to offer short-term, i.e. nightly stays for travellers, people who are not using a hotel as their dwelling, correct?
Yes.
Referring to rent payments, tenants and tenancies, that's to do with dwellings, isn't it? Not to do with hotels.
Long stay. They have to do with the long stay hotel apartments, sir.
If you have a hotel, just think about this normally. You have a lot of experience, okay? Even if it's longer term, as you put it, you don't refer to the people occupying rooms in a hotel as tenants paying rent in accordance with tenancies, do you? That's not normal.
Sir, as I explained in my statement, since COVID, we changed the format of our business from shorter stay to longer stay for obvious COVID-related reasons.
Yeah, come back to my question though.
What is your
You
question?
don't normally refer to people who occupy hotels as paying rent or being tenants in accordance with tenancies, do you?
We had to come up with...
Sorry, I do want an answer to my question,
Okay,
and then
what
of
is-
course you can qualify.
my-
You don't normally refer to people who occupy hotel rooms as paying rent or being tenants
Yeah, I agree with
or
you.
occupying as
I agree with you.
tenancies.
On a normal day-to-day normal hotel, you don't call them tenants.
Thank you. Long-term lets, right? Long-term lets is what you associate with dwellings, don't you? Something like an assured short hold tenancy for a 6-month period is what you refer to for a dwelling, yes? That's fair?
That's right.
Thank you. And whilst hotel rooms might share some characteristics with a dwelling, i.e. they might have provision for cooking some food, or they might have a bed, or frankly a roof. They're not interchangeable, are they? They are not interchangeable, a hotel and a self-contained residential dwelling. You can't just say the same thing is both, can you? Let's be realistic.
Could you repeat the question one more time?
It's right, isn't it? You say that they share some characteristics. Hotel
I didn't
rooms.
say that. The
Well,
council
do you
said
do you,
I
all right,
agree
you
with them.
agree with that
I
point?
agree with them.
Yes.
It wasn't my finding. It was the council's finding.
Sure, but you agree with it with
Yeah,
your
I do agree
experience,
with it.
yes? So a hotel room might have provision for some kitchen facilities, right? And it might, you would hope, have a bed, right? And it might have a roof. But the two, by which I mean a hotel room and a self-contained residential dwelling, they're not just synonymous. They're not just interchangeable, are they? They share some characteristics, but they are different, aren't they? Do you accept that?
But I'm not qualified to agree or disagree with
You don't need to be qualified. I mean, you are, because you have over 40 years experience in hospitality.
I can assure
But-
you, I still rely on advice from my planning officers.
Do you see that they might share some characteristics, but they're not just interchangeable words, are they?
They share quite a lot of characteristics, as the LPA have found, and they
Yes,
mentioned it
but
in their findings.
But that does
And I
not
agree with
mean
them.
Sorry.
I agree with them.
That does not mean you just use the two words interchangeably. Fair? Just because they have a kitchen facility doesn't mean a hotel room is a self-contained residential dwelling.
Sir, the self-contained residential dwelling is the finding of the LPA and we were that was confirmed in November 2025, during which time, since February 21, we have openly demonstrated to the council and that we were running it on a long-term stay with the kitchenette. And if the classification of my operation needs to be changed from hotel into flats, that is a matter for the council, and I need advisors, planning advisors for that.
You know the difference, Mr. Sabahipour, between a hotel room and a residential self-contained flat. Can I just look at two documents with you on that, please? The first is, can we go to NHC 12? So that's NHC 12.
You need to bear with me, sir.
Thank you.
Core document, the core document number.
NHC 12. So I did want to check.
I think it's CD4 something or other that the NHC ones come under.
So I've got just and I maybe be best to deal with this at this moment. I've got a core document list which has lots of CD references, which I think are the appellant's documents, but it also has NHC documents, which are the council's documents. Well, that's but they've got CD4, which covers a whole host of NHC documents. Right. Okay. Well, then let's do it this way. If you look at core document 4, so I'll work with that. Thank you.
It's in the third bundle.
Thank you.
I've got NHC 12, which is, I'll be talking about this, sir.
Yeah. If you look behind that, do you have an email from Simon Curling, 12th of January 2026?
1 second.
Just about the top page of NHC 12. Just look at the top. Does it say Simon Curling at the top?
No, it says James Grant. Then I've got Simon Curling. I've got Simon Curling here to my son Aiden. Is that the one you're talking about, sir?
Okay. I need to have this cleared up now. So can I ask one of my officers to just go and check that that is NHC 12?
Yeah, that's fine. Yeah.
Simon, it should be there. Yeah.
NHC 12.
What was the date of the
The first email is printed by Simon Curling, and it's James Grant, 12th of January 2026 at 16:28.
Yeah.
Is that the one?
All right, thank you.
Yeah, okay.
I don't know, sir, whether it might be helpful if we assist like that to speed things up. I'm not seeing any objection to that. If I can ask Simon to be sort of nearby, that might help. Thank you. Within that clip, okay, so we're just looking at what you know and don't know, Mr. Sabahipour. Can I ask you to turn to the back of that clip, NHC 13?
Yes.
And you should have 4 pages from the back, a typed letter dated the 17th of December 2025.
Simon, can you help me, please? Yes.
say NHC 13, yeah?
NHC 12
NHC 12 and in.
and 4 pages from the back. there's a letter which is dated the 17th of December 2025. Dear Michael Muir.
Yes.
Do you see that?
Yes, sir.
So do you have that?
Yeah.
I'm grateful.
Yeah.
This is a letter which bears your name. Yes, on the second page. If you look to the right-hand page, do you see your name at the bottom?
Yes.
Yes. Stated the 17th of December 2025.
Yes.
And do you see it refers to a call regarding the George Baldock first line? Do you see that?
Yes.
And then if you look, and it talks about the background and the COVID period. Do you see that?
Yes.
And then do you see the heading Templars Hotel?
Yes.
Yes. So this is your letter. Are you
Agree.
aware
Yes.
of
Yes.
this?
Yes. Yes. Yes.
Yes. And it says Templars Hotel, also under our ownership, provides relevant context. When we applied for planning permission to convert that property into residential apartments, we were represented by Mr. James Gran. See that?
Yes.
At the time, the council, it refers to an Anne MacDonald, asked through Mr. Gran whether we would consider letting the property as sheltered accommodation. The council was fully aware that the property had a C1 hotel use. Do you see that?
Yes.
And that sheltered accommodation was authorised under was not authorised under the existing planning permission. We were therefore operating at the council's request in a way which clearly fell outside the existing permission. And you talk about an acknowledged and obvious breach, right?
Yeah.
There, Mr. Sabahipour, you are showing, aren't you, yourself, it's a letter from you, that you had control, you had ownership of Templars Hotel,
Yes.
yeah, previously, and that you applied for planning permission to change its use from a hotel to what you call residential accommodation,
Yes.
yes? And you refer to a C1 hotel use that it was in, and that you needed permission to change that to sheltered accommodation. You had, didn't you? And you have an awareness of the difference between a hotel use and residential accommodation, don't you?
Sir,
You don't need Mr. Gran for that. You've written it here.
sir, this was word by word what we took from Mr. Gran to notify the council that this was what it was. And this was on the knowledge that I was gained by talking to Mr. Gran, because all along I on all of my application, you can check for yourselves that I always rely on the advice of a professional like Mr. Gran. And this was again checked with Mr. Gran that I am using the right terminology for the right application.
This letter bears your name.
It does.
And it does refer to the fact that you were represented by Mr. Gran, but it doesn't say that I've taken advice as to what I've put in here, does it? It doesn't say anything like that.
Well, sir, I don't know what you're trying to get to, but I can assure you this C1 or the planning application, all of that was by the advice of my planning advisor,
Yeah.
Mr. Gran, and we were seeking to get some common help with the application to house the YMCA.
Let me be clear. What I'm saying to you, Mr. Sabahipour, is that you can't hide behind Mr. Gran for everything, right? You know the difference between a hotel and a self-contained residential flat. See this document.
With respect, sir, between me and Mr. Gran, I will always want to use what he tells me when it comes to planning because he's better qualified.
Even if you do rely on him, I think this must be right. He's acted as your planning consultant throughout.
Yes, he has.
Yeah, and he does so on your instructions. Yes.
So does other planning advisors.
Correct. But insofar as we refer to what Mr. Gran says, he's doing so with your instructions. There's no part of what you're saying to say he went off on a frolic of his own. He said something that wasn't authorized. He acts on your instructions. Yes.
He acts on my instructions, but I'm sure you will agree that he works within the parameter of the planning law.
Sure.
And he is more knowledgeable about the planning than I am.
Yeah. Well, we've been through questions about what you understand and what anyone would understand a hotel to be. The second thing I just want you to look at, please, the second document is a planning application that you submitted before the 2024 one, all right, which we'll come to, all right? Can I just try this first? You did apply for part change of use of the ground floor restaurant to 2 residential flats, didn't you? You
Yes.
applied for that.
Yes,
That's
yes,
something
yes,
you're
yes.
familiar with.
Yes, yes, yes.
And that was an application which was subsequently withdrawn.
Yes.
Yeah. Let's just have a quick look if we can. Core document 1.1. Core document 1.1.
Okay. I'm going to be front of me, sir.
So do you see their planning application?
Yes. 1 second, please. Yes.
And I take it this won't be the first time you've seen it because it was submitted on your behalf?
Yes.
I mean, yes. And if we go to through the pages to page 5, the 5th page of it, you should have a page which starts, please provide a description of existing and proposed materials.
Yes.
Thank you. And if we go down that page, do you see a heading existing use?
Yes.
And it says hotel and restaurant, yes? And then underneath that, please describe the last use. Restaurant currently vacant, yes? Do you see that, Mr. Sabahipour? Bottom of that page, existing use.
The existing use.
Hotel and restaurant.
Yes.
Then you've got a box under that, restaurant currently vacant. Do you see that?
Yes.
All right, and then if you go to the top of the next page,
Yes.
residential dwelling units. Does your proposal include the gain, loss, or change of use of residential units? Yes. Yeah. And what's proposed is market housing. Do you see that?
It says no here, sir.
So you've got a heading residential dwelling units.
Sorry. Residential. This is the next page you want me to
Yeah.
look at. The next page doesn't say that.
Is there a box that says residential dwelling units?
Yeah, it is in, it's
Okay,
in the back
thank
of the
you.
bundle. Yes.
All right.
It does.
So
yes.
do you have that? I'm grateful. And it's just to check because you've fairly accepted that you made this application, right? But
Yes.
it makes clear, doesn't it? It includes the gain, loss, or change of use of residential units. Yes. And then what's proposed is market housing. And then you see housing types. And you've got two bedrooms. Yes.
Yes.
Okay. So that application, right, was submitted on your behalf. You're familiar with it, yes, for 2 residential units and then withdrawn, yes?
Yes.
Right. And then we come to, thank you, and then we come to the application 2024. Now, just the headline, I'm right, aren't I, that you applied for planning permission which included 4 hotel rooms on the ground floor.
Yes.
Yes. Now, if we please you can put that that document aside, but can you just go to your proof of evidence?
I just closed it.
Yeah. So I'm going to ask you to do it this way if we can, Mr. Sabahipour. There will be a lot of reference to your proof of evidence.
Okay.
So if I ask you to take out your proof of evidence, which is core document 12.
Better at it. No, I'm sorry. whole document.
Right. Can I ask you to take that out? I'm just going to, so if it's helpful, I'm just going to do this now. So it might take just a few minutes. Take out your proof of evidence, please. So you've got it to hand. Can you also please take out your statement of case, the appellant's statement of case, which is core document 9. Maybe Mr. Curling can help you with that as well. So leave that to one side. That's your proof.
Yes.
Can we take that out as well, please? Because there'll be a lot of reference to it, do you see? So I want you to have ready access to it.
No worries.
I don't know, Mr. Curling, if you can help with that.
Yes. I've got it, sir.
Right, so can you keep those 2 documents away from the bundles? Sorry to micromanage it, but it's just trying to be helpful.
Right.
All right, in fact, there's a stapler, so I'm just going to ask that those are stapled, please.
I've got them now, sir.
Thank you. So if you look at your proof of evidence, all right, so we're now talking about the 2024 planning application, right, which was included 4 hotel rooms on the ground floor.
Yes.
Yes. And if you look at your proof of evidence at 4.7, you refer to that. Do you see planning permission was granted by the council on the 21st of June 2024 for works to subdivide the ground floor of the property into 3 commercial units? Do you see that?
4.7.
4.7.
Yes.
Do you see the first 2 lines?
Yes.
Planning permission was granted by the council on the 21st of June 2024 for works to subdivide the ground floor of the property into 3 commercial units.
Yes.
Well, it was to include, it may have been for other commercial units, but it was to include 4 hotel rooms, wasn't it?
Yes.
Yeah. Okay. You are aware, Mr. Sabahipour, that went to planning committee?
Yes.
And Mr. Gran, your planning consultant,
Yes.
attended that on your behalf?
He did.
Yes?
Yes.
Am I right in thinking you were not there?
No, I wasn't there.
But there is a video of it.
Yes,
Yeah.
I've
Have you seen the video?
Yes, I have.
I'm grateful. And we've also provided a transcript of it.
Yes.
Yes. Have you seen the transcript?
I haven't seen the transcript, but I've seen the video.
Okay. So I'm going to try and deal with this as quickly as we can. All right. The previous application before 2024. Okay.
Yes.
What Mr. Gran said on your behalf.
Yes.
All right. And for your note, sir, this is NHC 31, is that the previous application, which did seek to, was for part residential, the previous one. Do you remember the one for the 2?
Yes, it was. The one that was
residential,
withdrawn. Yes.
which is now not the case because you're in 2024.
Yes.
It's to the hotel rooms instead. Yes.
That's right.
And then, having seen the video, you're aware, aren't you, that the councillors on the planning committee
Yes.
had a number of questions about the current use of the building, whether it was a normal hotel use, yes, and what the proposed use was, yes? I mean, broadly, that's what they were asking about, yeah?
Yes.
And on the transcript, right, I'm going to read to you from that.
Okay.
The chair of the planning committee asked specifically whether they are legitimate hotel rooms or bedsits by the back door. You remember that?
Was it referring to the 4 rooms?
Well, she asked whether we've asked questions about a normal hotel operation, whether they are legitimate hotel rooms or bedsits by the back door. Yes, do you recall that first?
I've seen this, yes.
Yeah. And the answer given by Mr. Gran was no, these are legitimate hotel rooms as part of the overall larger main use of the building as a hotel and restaurant. The restaurant is seeking to be reduced in order to be into a viable size, and in its place is adding to the existing hotel use of hotel rooms on the ground floor.
Correct?
Yes, you
Yes.
recall that?
Yes.
So what we can see from that, isn't it, is that 3 things were said. There is an existing hotel use,
Yes.
which is part of an overall larger main use of the building as a hotel and restaurant.
Correct.
And I'm going to say this, that what's proposed is legitimate hotel rooms. That's what I take from it.
Mr. Grant was fully aware of our PC, the first enforcement at that time.
Yeah.
So he was well aware of the inquiry, and he was well aware of the no breach on
Sure.
the response to the no breach for our long stay. And we were calling ourselves a hotel, and we are still calling ourselves a hotel
Yeah.
apartment today.
What he was stating to the planning committee dealing with that planning application in response to concerns raised by councillors as to what the operation of the building was and what was proposed is that there's an existing hotel use. The larger main use of the building is as a hotel and restaurant, yes, of the building, and that what's proposed is legitimate hotel rooms. Is that fair?
Yes.
Planning permission was then granted, yes. But what you built out on the ground floor was not 4 hotel rooms. They were built out as self-contained residential flats, weren't they?
They were built pretty much the same way. We haven't finished them because of the enforcement, but they were built in the same model as the rooms upstairs.
What's the answer to my question,
The
Mr. Sabahipur?
Yes, sir.
They were built out as self-contained residential flats, weren't they?
If the terminology of the hotel apartment is now called the flats, I am not qualified to agree or disagree on that. They've been built pretty much the same way as the upstairs, sir.
Let's look at that a different way. I mean, the crux of it is this, isn't it? You applied for hotel rooms on the ground floor, you got consent, and what you built out was residential flats, self-contained ones. That's what's happened, isn't it?
We have partly built them, and due to the enforcement that they brought some question on the legitimacy of the application on the ground floor, we put them stop to them. We haven't pursued them. They're still vacant. They are not being used. They've never been used. Yes, but at the time, much the same as upstairs, they were we called them hotel apartment. We're using them as a hotel, and even today, if you ask me, it's a hotel apartment. But we are agreeing with the council's findings that they are flats because their finding is classified these as flats, not ours.
I'm going to quote to you from the final comments, your final comments.
Okay.
All right. And sir, for your note, that's core document 10. And of course, Mr. Sabahipur, if you want to look at it, you can look at it. All right. But it's your own document. Paragraph 5.22. The appellant accepts, the appellant's you, isn't it?
Yes.
That the 4 ground floor units that were ultimately constructed are self-contained, which is why those 4 units are not within the scope of this Ground D appeal.
Correct.
So, just to be clear, you applied for hotel rooms on the ground floor, you got consent, and what you built out was self-contained residential flats.
Can I explain?
Of course you can
Would you
answer.
give me, sorry?
Of course you can answer. We're here to hear your evidence.
Let me explain. At the time that it was granted, we were of the opinion of all of downstairs was much the same as upstairs. With the enforcement in November 20, the finding in the November 2025, when they classified them as hotel apartments, again, I would like to reiterate, it is not my finding, it's the LPA's findings. We agree with them, but we have not used them. They are not finished, and they are still not being occupied.
Do you understand that you could have appealed this enforcement notice,
We
okay,
did.
on the basis that this didn't happen on the ground floor? You could have appealed it on the basis that what you have on the ground floor is hotel rooms.
Sir, I guess
Is that something you're familiar with?
I guess you're familiar with this being planning advisor, planning lawyer than
Yeah,
I am.
but I'm asking you.
Would you allow me to explain?
Yeah.
And I can assure you that the purpose of the 4 rooms downstairs was at the time when we applied for it was much the same as upstairs, but subsequently we were advised, whilst we are going through the appeal, it's best to leave things as they are and not pursue the 4 rooms again based on professional advice that we have done, and we are merely asking the inspector to look at it in 2 parts: upstairs, that it is immune; downstairs, which is not.
If what you had done, right, and been consistently advised was a hotel apartment, which was part of a hotel use, right, and they share certain characteristics, right, you could easily have appealed the enforcement notice either on the basis that this hasn't happened as a matter of fact, ground B, right? So you could have said, what we've done is the hotel rooms that we were consented, and you've just said what you did was what you were consented. Or you could have appealed on the basis that it wouldn't be in breach of planning control, because what you got is what you've always said, hotel apartments as part of a hotel use. But you didn't do that, did you?
With respect, I took advice and I followed the advice.
Okay. On a number of occasions, all right, so we can look at it again, we can look at it if you like, but I'm hoping you'll be familiar with it. For your note, so it's NHC 12. You asked the council to hold off from enforcement so that you could apply for planning permission. Yes? Do you recall that?
Yes, I do.
Yeah. I'm just going to give you some references. 9th of December. So this is all before. Okay, 2025.
I do.
Okay.
I do.
And the council said, and
No.
again, you can look at it, but November 2012, November 11th of December, sorry, 2025, the council says doesn't prevent you applying for permission, all right, taking enforcement action. 15th of December 2025, that was repeated. 9th of January 2026, the council says, well, you are able to submit an application for planning. 11th of January 2026, Mr. Graham saying, please hold off to allow a planning application. 12th of January 2026, please hold off. Can I just check, you're familiar with that correspondence? Is that
Yes.
fair? I haven't taken, yeah, you're aware of that, yes? No planning application has been made to retain the current use, correct? Despite you saying, through Mr. Gran and others, please hold off, we'll apply for planning. No planning application has been made.
Correct.
No ground A appeal has been made. You haven't applied for
Correct.
planning permission through this appeal. And what we do have is an application for ancillary offices on the ground floor. Yes, there's an application that you've
That's right.
submitted for something
Yeah.
quite different. Can you see how that looks, Mr. Sabahipur? Do you see how that looks?
How?
Here you are, okay, telling us that you've always thought this was longer term hotel apartments.
Yes.
Consistently advised. But what you've applied for and received in terms of hotel rooms in 2024, you've not built out and you've not appealed on that basis. And then you've trailed on a number of occasions the fact that you want to apply for planning permission and you've not applied for it.
Can I explain?
Do you see how that looks? It looks
Well,
like
you can
you don't
look at
have
it
the
whichever way
confidence
you
in the
want.
advice you've
Well,
been given.
I'm happy to explain, if you allow me.
Yeah, I'd like an answer to my question, and then of course you can explain. Do you see how that looks? It looks a bit like you don't have the confidence in the advice you were given. It looks like you're just saying what you need to say to get through.
I can show you that's your interpretation, not mine.
Okay.
I've been open and I've said exactly what we were doing, how we were running the business. Can I explain on that point? If you allow me, Inspector, please. If I would draw your attention to the first letter that was sent to us on I believe it was March 22. You can see how accommodating that letter was, which I would like the inspector to refer to that. I would like you to have a look at it too, to inviting us to make application for, and they will look at it and advise us accordingly. Subsequent to that, we received a letter with no breach. So there was no need for us to make any application. But you can see that the invitation is there in the with the council officer. And we, during the time that we were pleading with the council, hold off the enforcement. Can we talk to you and see whether we can find common ground? But the approach this time around was not the same as my usual approach that I always got from the council. Always, the fact that you mentioned one thing that it is very, very crucial to this submission that you made. So was that we withdrew application. The reason that we withdrew the application was because we realized that the council were not agreeing to this, when we simply were pleading with them during Christmas period, but the council, there was concrete wall in front of us. They would not listen to us. And this has never been the way that I have been treated with the council during my entire years of dealing with the council. I have got so much at stake, and I would want to work with the council. And to that end, we find it rather odd that why was it that this time around they were not engaging?
You're familiar, Mr. Sabahipour, with the point that you need to prove 4 years continuous use?
Yes.
The documents in NHC 12 that I've just referred you to, documents that I've just referred you to, so those constant requests to hold off whilst we apply for permission, yes? Those were attempts to stall enforcement action, weren't they?
It wasn't to stall enforcement action, sir, contrary to that, because we were trying to find common ground. We offered various through my agent, or whatever you want to call him, by my advisor, Mr. Grant, that there are other ways that the council can consider my application, but by engaging, but they were not engaging.
I'm going to move on. Now, I'm going to refer to a few points, and we're going to go through, Mr. Sabahipour, how matters are described now, okay, in your proof of evidence and in the statement of case, and how they were described previously, okay? Now, the first of those is with regard to rent, tenants, and tenancies. Do you recall we've already had a discussion about that, and
Yes,
you've said that those are words normally associated with dwellings, yes?
Yes.
Not hotels. If we just look, please, at your proof of evidence. What you say in your proof of evidence at 4.5 is rent is paid by each tenant on an all-inclusive basis. Do you see that?
Yes.
Yeah. And in the statement of case, so you also have that in front of you.
Statement of case, yes.
If you go to 4.8.
Yes.
The layout of the 17 studio flats. Do you see that? Studio flats within the building is as follows.
Yes.
Page 5, sir. Yeah.
I've got it.
And the statement of case at 5.4
Yes.
refers to tenancy agreements. Do you see that? 5.4, and then do you see halfway down the bullet points, tenancy agreements referred to?
Yes.
Yeah. So that's what you're saying now. All right. And that's how those things are characterized in your own evidence, but also in your statement of case. Now, I just want to look at how it was referred to previously. 2022, you are aware, you've mentioned it, that there was an enforcement investigation.
Correct.
Yeah. Can we just please look at NHC2? NHC2. I don't know if Mr. Curling can help with that.
Could you help me with this, please, Simon? Yes.
This is Sir, do you have that? This is an email from your planning consultant, 4th of April, 2022,
Yes.
in response to a council letter. If you've got it, turn back one and you'll see NHC1, which is the council saying, we've been advised rooms at the premises are now available to rent. Do you see that halfway down?
Yes.
Available to rent individually as self-contained flats,
Yes.
as opposed to a hotel accommodation.
Yeah.
Yes. And the response is NHC2 from your planning consultant. Yes.
Yes.
And dated the 4th of April 2022. And we can see James Gran with his qualifications. He's MRTPI, member of the Royal Town Planning Institute.
Yes.
Can you help me? Is there any mention of tenancies or rent?
So this is the
On this
first time I'm
page.
seeing this document. If you allow me to read it, I'll
Sure.
read it and I can talk
Yeah.
about it. If you give me.
Well, please do read it
Yes.
and then answer my question, please.
Okay. Yes.
Is there any reference there to tenants,
No.
rent,
No.
tenancies?
No.
Why not? That's the simple question. Why not? You're saying now that that's what you had. Why were you not referring to it then?
But he wasn't. Well, you're asking me about the letter that Mr. Gran has
Yeah,
wrote.
on your instructions, as we've agreed. Yeah. He acts as your agent.
He does act as my agent.
Yeah.
As I explained to you, sir, with respect, this is the first time I've seen this letter.
Mhm.
And I think the better letter for you to look at is my response to the inquiry, not this one, because I am, it's a 2-page letter and I am fully explaining how we are operating.
Yeah.
Which I don't know why you choose to read this one and not the other one.
Well, we will get there. The query that was raised by the council is that they'd been advised that the premises are now available to rent individually as self-contained flats. Yes, we've looked at that. Yeah. And this was as opposed to hotel accommodation. This was the response from Mr. Gran. Let's look at your response. NHC 47.
Yes, I've got it in front of me.
So this one, you know, we don't need to spend time with you reading
No,
it.
I'm familiar with this letter, sir.
Does it mention tenants,
No, it doesn't.
tenancies?
No, but it does
Why
explain.
not? Why not, Mr. Sabat?
It does explain how we're running the word in a hotel apartment. We were not using the word tenants.
But you are in. You see, you've given a statement for this appeal, and you've done a statement of case, right?
Yeah.
On your behalf,
Yeah.
which liberally refers to rent and tenancy agreements and tenants.
Yes.
Why were you not referring to it when the council asked about whether these were rented individually?
But we did tell them that they are rented individually on a longer stay.
You
with
didn't say the
kitchenette.
word rent. You didn't say the word tenant.
So
You didn't say the
we-
word tenancies, did you?
With respect, sir, whatever name you put on the funds we receive, whether you can call it rent or I don't know what else we can call it, hotel room rates or tariffs, they're all academic as far as I'm concerned. The operation that we were doing was disclosed to the council that we were doing a long stay and with the kitchenette. So and we were open about it, and you can, if you read this in fully, you can see what I'm saying.
You were the opposite of open about it. You weren't telling the true position, were you?
How would I have
Because Mr. Sabahipur,
Yes,
in
sir.
your statement for this appeal, now that you're trying to demonstrate 4 years continuous use of self-contained residential dwellings,
Yes,
you liberally refer to these as tenants and tenancies and rent paid. But when asked in 2022, specifically whether they are rented individually as self-contained flats, there's no mention of that, either in your planning consultant's response or in your own. Do you see the point?
I don't see the point.
I'm saying that you were not being full and frank with your answers about the way in which
That's your interpretation, sir. I've been open and I explained to the council for the word go.
If we look, please, at NHC 3, the next document. So this is now January 2025. Do you have a document dated 24th of January 2025?
Yes.
That one is a planning contravention notice, yes?
Is this the one in January 25?
5.
Country plan, yes. As I said, this is the first time I'm seeing this.
Yeah.
Okay. Well,
Yeah.
anyway, we
And
can talk about it.
if you turn over, you
Yes.
could have a document where hopefully, if yours is in color, you've got answers given to questions.
Yes.
Yes. And if we just go to the end of that, please, sir, do you have that? If we go to the page before the plan, all right, you should have a plan about 6 pages in. You've got a plan like that.
1 second, please.
And it's the page before that. I'm going to the end
That's
of the
the plan,
document.
the page
Yeah.
before. Yes, I've got it.
Yeah. Do you see it says warning under next to number 6?
Yes.
And it talks about offences if you fail without reasonable excuse to comply with the requirements.
Yes.
And it goes on to say, do you see it's also an offence knowingly or recklessly to give information in response to this notice, which is false or misleading in any way? Do you
Yes.
see that?
Yes.
What's that directed at? I mean, you must know this, Mr. Sabahipur, is giving full and frank answers, yes, to the
We have
questions that's
been.
asked. So we've just had a discussion around tenants and tenancies. Yeah?
Yes.
Go back to the start of this, please. Go back to the one that's headed important. This communication affects your property.
Where is that?
The second page of NHC 3.
The second page.
Yeah.
Yes.
Yeah. And if you turn through that, okay, your answers to the questions, all right, are underneath each one. All
Yes.
right. And if you go to F, can you see F? Are the terms of
Mhm.
occupation?
1 second, please. Yes.
Do you see what it says? Are the
Yes.
terms of occupation subject to any tenancy or license agreement? Yeah.
Yes.
And the answer given is yes. The terms of occupation are set out in check-in forms. Do you see that?
Yes.
And then it talks about hotel-style stays. Format and nature of these agreements are unchanged. Does it anywhere in that say that there are tenants paying rent pursuant to tenancy agreements, as you now say?
Obviously not, but we do we can call our stayers our guests or hotel occupiers. You can call them whatever that comes to mind. Yes, in here there is no mention of tenants, but there are long stay occupants of our hotel apartment.
What you refer to is check-in forms, yes?
Yes.
And I'm going to suggest to you, Mr. Sabahipour, okay, that there are only 2 check-in forms in place at this time. All right. And sir, for your note, core document 3.3.48 and core document 3.3.54. There are only 2 of those hotel style check-in forms.
Is it in this bundle?
Mr. Curling, do you want to help with that?
Yes.
There's quite a few here.
There's quite a few of them in here. So if you could,
Yeah. I don't want to take you. I don't. What I'm going to do is say this to you, Mr. Sabahipour, that there's only 2 that we have found of those check-in forms in existence at the time you answered that question.
yes.
And if I'm wrong about that, all right, either Mr. Bell will take you to the others, all right, or you can assist the inquiry later, all right.
Yes.
But what I'm asking you is the same question, Mr. Sabahipour. Why would you not refer to tenancies and rent when asked whether the terms of occupation are subject to any tenancy or license agreements, with a warning that you mustn't give misleading statements?
Okay. I think my daughter is better placed to respond to this question of yours, sir, because she was running the day-to-day running of the hotel apartments, and she will be more than happy to. She will try to respond to your question. If you could.
You see, this is a planning contravention notice which is completed by you in your name.
Yes.
Yes. Does it? Yes, it gives your email address. Yeah.
Yes.
And the email address for James Gran.
Yes.
Yes. Doesn't refer to Nasli.
But I
your
can
daughter.
show you it's a family business. We run it closely together. So
Sure.
I own and she works. She goes closely with me.
Um,
It's not unusual to have a family member to work alongside you.
Okay. Next, we're going to just look at a few of these. All right. Self-contained dwellings. Okay. What you're saying now. All right. Let's look at your proof of evidence. Look at your proof of evidence at 3.1.
Yes.
You say from when the kitchenette was installed, it was self-contained. Yes.
Yes.
And 4.4, the first of the 17 units was rented as self-contained accommodation. Yes.
Yes.
And then if you look at the statement of case, all right, for the appeal, so what you're saying now, 5.5,
Yes.
they function, 3 lines down, they're considered to function as 17 independent residential units, yes?
Yes.
And 5.8,
Yes.
top of page 8. The 17 flats are all self-contained dwellings, yes?
Yes.
That's what you say now. Should we just have a look at what you were saying previously? If we go to NHC 2 again, please. All right. So remember, we're going back to 2022.
Yes.
And the question that was asked is, we understand they're now available to rent individually as self-contained flats. Yeah.
Yes.
Look at what Mr. Gran said on your instructions at NHC 2, please.
Yes.
The rooms, do you see there's 3 paragraphs down? The rooms are not self-contained dwellings. Do you see that?
Yes.
As there is no clothes washing facility, etc. Do you see that?
Yes.
So it's one thing not to say what the position is. It's another to deny it altogether. The rooms are not self-contained dwellings. In answer to a question, we understand they're rented individually as self-contained flats.
Yes.
I'm going to just suggest to you, all right, that in your letter that came with this, there's no mention of self-contained dwellings.
My letter is the letter I referred to, sir, which is the April 22. I think
Yes.
you should read that alongside with this, and
Yeah.
they both combine. And I trust Mr. Gran to have used the right terminology for what I was using the rooms for.
Okay, so let's do it this way round then. If you go to NHC 47, that's your letter that went with it.
NSC 47.
Yep.
Yes.
Does it say anywhere that these are self-contained dwellings?
No, it doesn't, but it does explain how we were running the business. Whether you,
Yeah.
the terminology of the unit,
So-
whether it's a self-contained dwellings or flats or hotel apartments, are something that I'm not qualified to come to agree or disagree on this. We are explaining how we were running it as it was in since February 21, and it is being run the same way now, sir.
So your consultant on your instructions, acting on your behalf, was saying expressly they were not self-contained dwellings, and you were not referring to them as self-contained dwellings anywhere in your letter. We can agree that, can't we?
We are still calling it hotel apartments.
When asked that specific question, right? If we just go to the planning contravention notice response, what that refers to, so that is NHC 3. Do you want to have a look at NHC 3?
Yes.
What that speaks of, do you see the second page up where it starts with important, this communication affects your property? If you look at E, it appears that they've been rented out as short-term accommodation. Do you see that, Mr. Speckle? Yes. And underneath that, do you see 3 paragraphs down? It says, unlike residential flats, the rooms function as self-contained hotel units.
Yes.
So again, we see, don't we, that you're representing that these are not self-contained residential units. You're pushing the council away from the idea that these are self-contained units expressly by Mr. Gran, by not mentioning it yourself, and then in response to a PCN, you're saying they're not like residential flats because they function as self-contained hotel units. Yeah?
we are still maintaining the fact that they're self-contained hotel apartments. The findings of the LPA in November 25, they consider them to be flats, and we are agreeing with them based on our advice.
Can I just understand this? Because we've said that the normal occupancy of hotels is travelers, yes?
Yes.
People for 1 night, 2 nights, and so forth. Okay, you do get, of course, you get ones who stay for a bit longer, but it's short-term stays. Okay, it is not usual for someone to treat a hotel room or a hotel apartment as their dwelling, as their only or their principal home. Is that fair?
We don't police how they use our unit when they're staying on a long-term basis, whether they use it as their main resident or they use it as a place to stay and go home to their main resident by weekend. That some of our guests do, and they did. So really, whether they use it as their main resident is something for our guests or tenants, whichever one you want to terminology you wish to choose. The people that they're staying within our property, they can choose to either use it as a main residence. If they do, we would not know whether they are doing it, or if they use another address as their main residence.
Because you're familiar with Nazli Sabahipour's evidence, yes?
Yes, I am.
I mean, she says that there's three residents that have been occupying rooms since the 1st of March, she says, 2021.
Yes.
Yes? So 5 years, as at today's date.
Yes.
And she refers to a tenancy bundle that relates to their occupation. Yes?
Yes.
Are you familiar with that?
Yes.
Yeah. Before her statement, I think what we had was the response there was a second planning contravention notice in December 2025.
Correct.
Yeah. And we were given information about, at that stage, after we were about to serve the enforcement notice, we were given information about historical guests of the hotel and current guests.
Yes.
Yes. But before that, all right, so that's what it says in the statement, and before what it says in that PCN response, there was no mention of longer term tenants like that, were there? We've been through the documents.
You're asking me my daughter's witness statement.
No, I'm asking you whether you're familiar with what she says, that there's
Yes,
been
I am
some
familiar
residents
with
there
what
for
she
5
said, yeah.
years,
Yes,
right?
yeah.
And what I'm putting to you is that before the PCN response in December 2025, which is NHC 11, there was no mention of those individuals who'd been there for years, was there?
Sir, when the inquiry opened, the first inquiry opened 2022, they must have been with us for over a year. We did not know whether they're going to extend their stay with us. Even now, we don't know whether they're extending their stay with us. They may give us service with a notice and vacate tomorrow. But what we are saying is, we've given you that there are some longer stayers with us, and whether they're using this as their main residence remains for them to identify whether this is their main resident or not.
Well, even if it was 2022, right, and they'd been with you for over a year, that was not something you were telling the council, was it?
I did.
That you had certain residents who'd been with you for over a year. Never mentioned, was it?
We were never asked to give any more evidence. What we've given the council at my letter of April 22, that the stayers are on long term.
Can we just look briefly, please, at NHC 11? NHC 11. Mr. Curling, can you help with that?
Yes.
Can I just put this to you with regards to certain of those residents? I think there's 3 of them who've been there for 5 years, That tends to suggest, doesn't it, that they're living there? Is that what you're saying, or is it that you don't know?
I don't know.
Because what is said in this PCN response, all right, so this is the one December 2025, after the council, you're familiar with this, I hope, the council had concluded that there'd been a material change of use to residential accommodation, self-contained residential accommodation, but you were required to do a further PCN, which you submitted, and that's this one. Yes? Is that sound right? Yeah, okay. And if we look at what this one says, it's got the same warning, and do you see 5 pages in, there's the PCN responses, 11th of December 2025. Do you have that, sir? Yeah.
Is it from who to who?
So within the within NHC 11, there should be
Yes.
document 11th of December 2025, before the enforcement notice was actually issued, okay,
Yes.
but after the conclusion that there'd been material change of use. And it's got answers given to the questions. And this is the first time we see reference to tenancy agreements. Do you see that? A third of the way up the page. Tenancy agreements under B.
Yes.
And then under mail arrangements, do you see this? We receive very limited mail for guests as the George Hotel is not used as anyone's permanent residential address. Do you see that?
Yes.
Now, what we know at this time, what we know now, is that 3 of the residents had been there since March 2021, right?
Yes.
So 4 years, 4.5 years.
Yes.
Are you really just saying you don't know whether they were living there? Or is it that you were throwing the council off the scent by saying no one lives there as their permanent residential address? Because that's what it looks like now, doesn't it? It looks like 3 residents have been there for 5 years, paying monthly rental, you say,
Yes.
for a great deal of time.
Yes. So
But what you're telling us
what
in
is
this
the question?
PCN, what you're telling us in this PCN is it's not used as anyone's permanent residential address.
Even now, I'm under oath here. I still don't know whether they are using it as a residence.
Then you could have said, couldn't you? It's not known. If you were being full and frank, you could have said it's not known whether anyone is using the property or a room as their permanent residential address. We
yes.
don't know, right? That's what you're telling me. But in this response, you're being quite clear. None of them are using it as their permanent residential address. So is that not accurate then?
But when we made this, we were at the knowledge that what we are giving is accurate.
But now you're saying you don't know.
I didn't say that I don't know. You're saying to me whether what is accurate or not. It was accurate, and even if you ask me whether not only these 3 people, any of them are using it for their, it is not for us to find out whether they're staying with us.
Yes. You see the difference, Mr. Sabahipur. If you didn't know and you don't know, then you don't know. Okay. But by saying, and that's what you should say in response to a PCN, a planning contravention notice.
Yeah.
Okay. You've not done that. What you've said is you've been categoric and you've said none of the people, it's not used as anyone's permanent residential address.
That's
now,
what
you said that then, okay? And now what we know is, or what you're suggesting, because it's for you to prove, is that 3 occupants have been there for 5 years.
When we made this statement, we made it with our best intention. Even now, if you're asking me whether they're using it as their residence, I give exactly the same answer.
Okay. Can I see if there was any doubt or any concern or anything that was unclear about this, you could have come in and spoken to officers, couldn't you, yourself? Is that fair or not? You tell me.
Sir, the officers were not engaging. We demonstrated to you time and time that we were trying to engage with the officers. The officers were merely concerned about issuing an enforcement. They were not engaging. As I said, this is an odd one on me. I have always worked with the officers. I've made many planning applications in my time. I've never had this, ever.
Right.
This is the first appeal that I've ever made over the last years. That have 45 years I've been in Bulldog, and I've done quite a lot of substantial work with construction, and I have never been in this situation before because the officers did engage with us, but this time around, oddly, they were not engaging.
Okay, this time officers were not engaging. Can we look at NHC 3? NHC 3, which was the first planning contravention notice.
Yes.
Do you see a letter dated the 24th of January 2025 from North Herts Council?
Yes.
Do you see the second paragraph down? The notice offers you the opportunity to make representations to the council in person about the use of the premises. I've made provisional availability for you to attend the council offices, and it gives a date and a time. Please could you advise by the 3rd of February if you wish to take up this opportunity? It's a letter addressed to you, isn't it?
Yes.
Did you take up that opportunity?
We have had 4 visits by
No,
the...
Mr. Sabahipur, that won't do. What's the answer to my question? And then, of course, you can qualify. All right.
Yes.
An opportunity is given to make representations, and provisional availability is given to attend the council officers to do that. Right. To you. Did you take it up?
We took advice on this, and my advice was to give a written representation, which I have done. Fully written evidence, it has been given to the council in time.
So the answer to my question is no, you didn't take that up, but you decided on advice to make written representations.
From a barrister, qualified barrister, who has advised me that I can do give a written statement to this inquiry.
You are referring, I believe, to what's called a statement in lieu of attendance.
Yes.
Yes. To an interview under caution.
Yes.
That came later. If you look at NHC 13.
Yes.
So now this is 16th of April 2026.
Yes.
And it's in response to Christella Menson. And that was a statement you provided in lieu of, instead of attending an interview under caution with officers. Yes.
Yes.
In relation to the answers you'd given in the PCN.
Yes.
So an opportunity was provided to come and set the record straight, if I put it that way. Of course, it would have been under caution. All right. But that's the second opportunity you passed up by providing a written statement instead.
What was the first one, sir? I've missed the first one.
The first is the one we just looked at, which is January 2025. And a provisional availability was made at the council offices to come in and make representations.
But I did explain that based on that request, I took legal advice, as I always do, and the advice was given is to send the statement, which I have done in time.
Okay, so I'm gonna say there's 2 occasions when opportunities have been made to come in and address the council's concerns. I'm going to ask you to look, please, at NHC 7. NHC 7.
Yes.
So this is now 22nd of September 2025 from Mr. Curling to your son, I believe, but copying you in.
Yes.
All right. And the opportunity is given, isn't it, to consider applying for a certificate of lawful development
Yes.
concerning the current use.
Yes.
no LDC application was made, was it?
We were advised what we are doing is lawful.
So I'm going to suggest to you that a number of opportunities were made to engage with officers, which were not taken up.
I don't agree with you with that, sir.
Okay,
Because
well,
this was the only time that they said that to make an application on a lawful, and our advice was that the operation that we are doing is lawful. We don't need to make an application for lawful development. Again, based on the advice.
can we just come to this? You said that this time around officers did not engage. Plainly, from the documents I've just taken you to, they did. They did engage with you. They made offers more than once for you
When
to
was
come
the
in and
first time
explain.
this is said more than once, sir? Where was the other time?
So January 2025. All right. We've then got the interview under caution and an offer to set the record straight through that. And then we've got, if you like engagement loosely, making an application for an LDC. That's invited of you. There's three examples of officers engaging with you without going to an enforcement notice or before going to an enforcement notice.
Let's agree to disagree because I don't agree with you on this.
You've avoided engaging until the council took its view, and until then the council issued its enforcement notice.
Avoided?
Engaging with officers face to face
How could
to
we have
explain the
avoided-
position.
How could we have avoided, sir, that we've my instruction to my two children, which is sitting there, was to welcome any visits by the councils. And I have never seen these people in here. This is the first time I'm seeing them. They've never seen me before. They came 4 times to and invest during their investigation, and 4 times known, and few times that we didn't know that they came unannounced. We have given the council all of what we had: tenancy agreement, bank statements, and we've explained how we run our business. And I can't see how we could not have engaged, how more we could have engaged with the council.
What we don't have is any statutory declaration, statement, witness statement, or even a letter from an occupier of any of the rooms. Is that right?
Sir, let me bring this to your attention, also to the inspector's attention. When I believe this is how it appeared to be, that one day that the officers turned up unannounced, wanted to gain access. The access was denied. Subsequent to that, they asked us to give them details of our occupants, all of their names and addresses, and they were written to each and every one of them. So they are in contact with the addresses of our occupants, and we disclose this to them when they ask.
So what's the answer to my question, Mr. Sabahipur? We don't have, do we, any statement, any statutory declaration, any letter from any of the occupants of these rooms, either now or previously over the last 4 years? We don't have that, do we? And what we do have, because you've just referred to it, if you look at NHC 9, please, NHC 9.
Yes.
Is correspondence. So if you go in NHC 9 to the 3rd page, you should have a redacted email, 3rd of December 2025.
Is this the one?
So it's 3rd of December 2025 at 17:26 at the top.
Yes.
Yeah. So do you have that?
I have it.
Yeah. And there's a few matters raised in this correspondence from your son. And you see in the middle, contact with guests. We're extremely concerned to learn that you, that's officers, along with your colleague, attempted to access the site without prior notice to approach individual guests directly and deliver letters that could result in fear-mongering. Do you see that?
Yes.
Completely out of line, especially when no enforcement action has been taken. And it talks about access to the rooms and so forth. And it says planning matters must remain strictly between the council and us as the operator. Do you see the response to that on the second page?
Yes.
Do you see in the middle contact with guests, which cites on the second page, the page before that?
Page before that.
Yeah,
Yes.
in the middle, it talks about the provision under which officers can exercise investigative action.
Yes.
Yeah. I trust that you're aware that the council sent formal letters to the occupiers of the units. Please can you confirm they were passed on to the occupiers when their PCNs were served? So the council has tried to get information from the occupiers, and it's been resisted by you.
It
Yes?
has not been resisted by us. We are none of the wiser to how the council contacted them after they were contacted. We learned that they were contacted by the council. Whether they choose to engage with the council is a matter for them to do. But they were contacted by the council, and whether they received or they didn't receive, I'm not here to say the letter was sent by the council or they received it, because it is nothing for me to respond to that. But whether they respond to this, I was sent pretty much the same letter, and when I got it, it is a very if I was a tenant, it is alarming that the reason that we were my son wrote to Simon Curling was that we were very, very accommodating based on my instruction to my children, and there was no need for them to basically come unannounced. I think they would have had a better reception, and they would have had much better result if they would have announced their arrival.
By saying it's completely out of line, and saying that planning matters must remain strictly between the council and us as the operator, you were seeking to prevent officers from contacting occupiers, weren't you?
Well, we subsequently gave the details, and they managed to contact the occupiers, because it is fear mongering. I agree with that.
Can I just raise one other factor, please? Just going on the kitchenettes, please.
Yes.
I'm just going to do what you're saying now versus what was said previously on this as well, please. Can we just look at the statement of case? You should have the statement of case.
Yes, I've got it in front of me.
And if you look at paragraphs 5.6 and 5.7.
Yes.
All of the flats, 5.6, have a bedroom, a bathroom, kitchenette with full cooking facilities, with many having dining table and seating areas, yes?
Yes.
And then in 5.7, it says every unit has cooking facilities and a well-appointed compact kitchenette installed.
Yes.
And it goes through what's included. Do you see that?
Yes.
If you just look at what your statement is to this inquiry, paragraph 7.6 of your statement endorses the same, right? Refers to the statement of case and says the same, yeah? So you should have that separately.
Probably loot inside, because we took it out and stapled it.
Yeah.
Okay. Well, if I put it to you this way, Mr. Sabahipur,
Yes. Yes.
you make the
I've
same point. Yeah. If you just have a quick look at 7.6 of your statement.
7.6.
7.6.
Yeah.
So reference to full cooking facilities and what every unit has in terms of cooking facilities, both in the statement of case and referred to in your statement. Yes.
Yes.
Can we just compare that with what was being said? If we look at NHC 38, please. NHC 38.
Yes.
So just bear with me one moment. So this is an email from your son, 19th of October 2025.
Yes.
And it's to Mr. Curling, and it copies you in with
Yes.
Mr. Gran.
Yes.
Yeah. And if we look at kitchenettes do not change the use, number 4, do you see that?
Yes.
So do you have that?
Yes.
I'm grateful. These amenities, so each room includes a small kitchenette, a feature we clearly disclose. These amenities, mini fridge, kettle, microwave, are standard in many hotels, allowing guests to make simple refreshments or snacks for their comfort.
Yes.
See how that's put?
Yes.
It's seeking to minimize the kitchenette that's there, isn't it? By referring to simple refreshments and snacks. Whereas now you're saying we've got a full cooking facility.
Well, as I explained, there was the smallest kitchen unit that we could have bought in the market. Some of them only 1 meter, and some of them could be slightly smaller. And it's a compact kitchenette, and they have the features which we've explained time and time again, that they have got sinks, they've got microwaves, and again, you need to remember, sir, the installation of the kitchenette was in time of COVID, so we needed you need to be mindful of the fact that the reason that for us we changed the use of the property was during and soon past COVID, and to give them some areas that they can feel safe, that they can have some time without worrying about COVID. And yes, it is. If it is, and what we have got is bigger than what is explained, then it is remains for your interpretation. But
Well,
we could
this
not
is
have
very
got
clear.
any smallest kitchenette that we could have
Yeah,
got.
it's how it's put. All right. At this stage, you're saying simple refreshments and snacks through a kitchenette, small kitchenette. Now you're saying full cooking facilities. Look at the next sentence. It does not enable independent living.
Okay.
Sorry. Okay. That
No, I'm sorry.
that is saying
I
something
didn't realize
directly opposite. That is saying
So-
something directly opposite to what you're saying now, isn't it?
I do apologize. I thought you could finish with your, but you haven't finished with your.
Yeah.
All
All right, then let me put it again.
Yes,
By
please.
saying it does not enable independent living, you're saying something directly contradictory to what you're saying now in this appeal.
This is a letter that my son wrote to Mr. Curling,
Yes.
and
Was he acting on your instruction?
he was acting on my instruction.
So he is saying in terms that the kitchenettes are small, they allow for simple refreshment, they do not enable independent living. That's what he is telling officers at the council by email on the 19th of October 2025, isn't he?
Yes.
And you're saying the opposite now. You're saying they do enable independent living.
I didn't say that they do. I did not say that they do offer independent living. Whether they choose to live there or elsewhere is their choice.
Just keep hold of that, Mr. Sabahipur. Just look at the statement of case, your statement of case at 5.5.
Yes.
They're considered to function as 17 independent residential units. That's what you're now saying.
This is
Yeah?
the finding of the LPA, sir.
This is your statement of case,
Yes.
right? On your behalf.
Yes.
We've been to that previously. You were saying something directly opposite to that in October 2025. Yes?
Can I respectfully ask you to take a look at the date of this statement, which is April 26th. This is after the enforcement.
If the kitchenettes that were installed enabled independent residential units, self-contained independent residential units, then why not say so in October 2025?
We said
But
it-
more importantly, Mr. Sabahipur, why say the opposite, that the kitchenettes do not enable independent living? That's directly the opposite of what you're now saying, isn't it?
Okay. In my letter of April 22, we've explained the long stay with the kitchenette. We have always welcomed the inspectors to come along and inspect place. Whether any of our guests, tenant, whatever terminology you use for those stayers within our premises, choose to make a full use of the kitchenette is really it's something that it is there as a facility. The bathroom is there as a facility, whether they use it or not. This is not it's not in my control. So really, as far as I'm concerned, we've got facilities there for them, which adds to our offering.
Okay, Mr. Sabahipur, I just want to put this to you, please. When you look at all of these various aspects of what's happened, what you've said, what you say now versus what has been said previously, both you or those acting on your behalf have engaged in positive deception. Do you have an answer to that?
I didn't listen to the question. I was looking for some water, sir.
Both you and those acting on your behalf have engaged in positive deception.
I can disagree with you entirely.
They have stated the opposite of what's actually happening. They've not given full information, for example, with regard to tenancies or misleading information. They've minimized features which are consistent with self-contained dwellings, see the kitchenettes. You've avoided engagement with council officers. There's a number of elements which amount to positive deception. Do you have a comment in relation to that?
I totally disagree with you, sir. We have been open from by responding to the first inquiry, which was in March 21. We told the council that we are doing long stay with the kitchenette. We welcomed, and it took them, I mean, we need to be mindful of the fact that it took the council 2 years to come to a decision. So we received a notice in 2024, March 2024. You have 2 years of cloud hanging over you, and during which time where we welcomed at least 4 visits from the council. We disclosed all the residents' details. We gave the bank statements. We gave all the tenancy agreements, and I fully disagree with the fact that we've kept anything with the council. It is not in my interest because I've got too much at stake, and I work closely with the council, and I would like to keep my relationship intact.
The documents and answers that we've looked at, those same points, they've sought to undermine the planning process, and you've sought to delay enforcement action or throw the council off the scent of what was actually going on here.
Every PCN that every letter that we've been sent, we responded in time. So how could we have delayed it? If anything, it was us chasing the council. I mean, I would like Simon Curling to vouch for that we've always wanted the council to give us a response. And it was the council who was delaying it, not us.
If you succeed in demonstrating the immunity of the 17 rooms, you will have a valuable asset, won't you? One that is profitable, because you'll be able to rent them for long lets. Is that fair?
We've been renting them for the long lets from February up until now. I will
Yes.
continue to do so. Whether it is so, I don't know the question. What are you saying?
Well,
that would add?
you were saying, all right, that at the time coming out of COVID, this was about commercial viability.
Yes.
Yes. But if you succeed in demonstrating your Ground D case, if you
Yes.
succeed in saying these are actually, they've been independent, self-contained
Yes.
residential dwellings for a continuous 4-year period, that will be valuable. That will be profitable, won't it? Inevitably. I mean, you can let them as for considerable sums for long periods.
I can assure you the Ground D only became known to us when we received the enforcement.
Mr. Sabahi,
And
what's
I've never
what's the,
considered the value of whether it enhances the value or not. I'm going to keep the business and the property for me and for my family in the future.
come on, Mr. Sabapil. You're well experienced in the hospitality sector. You also have a property management element to that. You've got Templars Hotel as well. You've got other
Yeah, I have got
property
properties in
elements,
Bulldog. Yes, I did say that. Yes.
They will be valuable if you succeed in your Ground D appeal.
Yes.
You will have on your case long-term let accommodation, 17 units.
Yeah.
Which you can let for sums of money. That's going to be profitable, isn't it? It'll be immune from enforcement if you succeed on this appeal. That's going to be profitable.
I
isn't
never
it?
looked at it that way, sir.
Okay. Finally, sorry, sir, just getting slightly over. Got 5 minutes, if I may. Just in terms of what you submit in support of your appeal, you rely on documents primarily. Evidencing what's happened, the tenancies and the guest check-ins, invoices and that sort of thing, yes? As we've said, there's no supporting statements from any of the occupiers. And we can agree, can't we, that if we had occupiers, they would corroborate what's said. They would support, yes, I've been living there, I've been occupying for this period, yeah?
Yes.
In terms of the kitchenettes, we have invoices that show when they were purchased. We don't have any evidence which demonstrates when they were installed, do we?
So we've given you the invoices of the workmanship.
Yeah.
And the kitchenette. When they come in, they are fully they've got everything in them. So all you need to do to just plug it to an electric and make a connection to the waste.
Do we have
we've given you invoices.
Do we have a statement from the person who installed them as to when that
We've given you all
happened?
the invoices.
Do we have a statement from the person
never,
who actually installed
never
them?
occurred to us to do that, but we've given you all the invoices, and the tenancy agreement is or the rent that we've got. The schedule of tenancy agreement and the rent, you can see that they've been living there, they've been paying us rent. So, and we would not have bought 17 kitchen by not putting them in. There's no reason for us to do that. So we installed them, and you've got the invoices for the workers that they did the installation, and they've been in use. The first one was in use in February of that year.
Where those records are not complete, so they don't cover the whole period, or documents are unsigned or undated, they don't demonstrate continuous use as self-contained residential dwellings, do they?
The question is, could you ask the question one more time, please?
Where those records that you've put forward are not complete, they don't cover the full period, there aren't tenancy agreements, they're not signed, they're not dated, they don't demonstrate continuous residential occupation as self-contained dwellings.
We've given the council all of what we had, which is all of the tenancy agreement. And if you would have allowed the submission this morning, you could have seen the signature on the agreement. They would, you can see the rent being paid on those units, and you can see the continuation of of the agreement. The fact that they stay for longer than 1 month or 1 year or 2 years, the testimony to the way that we look after our guests, tenants, or whoever you want to call them.
Just bear with me a minute. Here's my questions.
So I'm reluctant to interrupt. We've been going for some time, and I'm conscious there's been a lot of water consumed on this side of the room as well as that side. I'm just a bit worried about the appellant carrying on without being offered the opportunity of a comfort break.
Yeah. Well, I mean, I could probably do one as well, to be perfectly honest. Are we happy with a short comfort break? Then obviously we'll have the examination, then potentially break for lunch after that. Would that be fair? Okay. Should we adjourn until 1 o'clock? Is that enough time? 6 minutes? Yeah, it's okay. Okay. Thank you. The inquiry is adjourned.
Almost like told you stop and done it.
Okay, the time is 1 o'clock and the inquiry is resumed. I think there's just one question for me, Mr. Sabahipour, before I pass back to Mr. Bell. The planning contravention notice in January 2025, which is NHC 3 in the bundle, which I know you've been taken to already. And it was mentioned that your answer to question F on that, which was in relation to are the terms of the occupation. Sorry, I'll take you to G. My apologies on that, which is state the names of the current occupiers and provide the dates and duration of their stay/agreement. To which you've responded, due to data protection and privacy regulations, as well as our duty of care to our guests, we are unable to provide the personal details of individual occupiers. Could you explain why that was your position in early 2025, and then subsequently those details, i.e. tenancy agreements, etc., have subsequently been provided? Why did you not provide them on the earlier PCM? This PCN was dated, bear with me, the 24th of January 2025. You would have responded obviously after that date. Sorry, 20th of March 2025 was the date of your response. Oh, the microphone, sorry. Apologies.
Yeah, I apologize. We were of the impression we did not need to disclose, and we thought maybe this is we are not allowed to disclose people's details, because we have got people that they're saying that maybe they didn't want us to disclose it to the council. But subsequent to that, when we took advice, we were told that yes, we have to disclose it, and we did in good faith. So we have subsequently we did. But I can't remember when was it subsequent to that we responded to this.
Well, you responded to that PCN on the 20th of March 2025. Then there was another PCN in, was it November? I can't remember, I've got it in front of me. November, December, later 2025, which you did respond to.
Yes.
And obviously, in this appeal, we've got all the various tenancy agreements, bank statements, and etc. So my question really was, what changed between March 2025 and December 2025?
Advice, sir. We advised differently subsequent to that. So we listened to the advice initially, and we also listened to the advice subsequently, and we responded to, and we gave everything else apart from the personal details.
Well, that moves me actually on to the next point, because you said you were unable to give that information because of privacy. At that point, the advice was you couldn't give that information, but it obviously asks for the names of the current occupiers, but it also asks for dates and duration of their stay agreement. So, could you not have given, even if you didn't say it was Joe Bloggs, for example, who lived in room 1, could you not have just said room 1 has been occupied for 2 months or 6 months or 9 months or whatever it happened to be? Because that question is asking for 2 bits of information. Essentially, it's asking for their names and also the duration of their stay.
Sir, since I was, my daughter was running it on a day-to-day basis, respectfully, would I ask you to ask the question of my daughter? I guess she would be able to respond to this.
I can ask her, and I probably will if it doesn't already come up in obviously the questions. But this is a PCN that you have signed, remember? So
yes,
they are your answers, not your daughter's or anybody else's.
As I explained at the time, the advice was then, and subsequent advice was that we was different.
Okay, so just to clarify, the first time final point, so the first time that you gave the council the tenancy agreements was late, is it December 2025, after the second planning contravention notice? Is that correct?
I am not familiar with the dates, sir, but if that's the case, then I agree with you.
I'm asking you, I've just referred to the early 2025 PCN, which we've just discussed. Then there was a second one in, I think it was dated November 2025. Thank you.
NHC 11.
Oh, there we go. Okay, thank you. Thank you, Mr. Bell. Yeah, NHC 11.
Yes, sir.
So just so I'm clear, that is the first time. Is that the first time that you provided the council with tenancy agreements? Because it says refer to Schedule 1, etc.
Yes.
Yeah. Okay. Thank you. No further questions for me. I'll pass back now to Mr. Bell.
Apologies. I just have a couple of questions by way of re-examination. During your answers to my learned friend's questions, you periodically referred to the council's findings. I just want to be absolutely clear by what you mean by that.
The definition that the council's investigation was, they came up with, that it was a flat, that definition was told to us or in, I believe, November 25.
So if I'm to understand your answers now with that borne out, what you were saying in response to the questions is you were referring to it as a hotel up until the point the local authority said they were flats.
Yes.
And in respect of the terminology that was put to you, at times you use guests and at times you use tenants. How do you explain how that terminology changed from guest to tenant?
I guess on the long stay, we could call them tenants, or we could call them guests. But I just want to draw the inspector and the panel to the that didn't make any difference to the way that we were running the business. The business model was long stay, and it was with a kitchenette, and we've demonstrated that we've given all the details of the people that they stayed there, and the bank statements, and etc. etc.
I want to ask you just a couple of points in respect of engagement with officers. It was put to you, I think, that there wasn't any real attempt to engage with officers over this issue. I want to just take you to some documents that you've already been taken to, but you were taken to specific points within those documents. So if we could go to, apologies, if we can go to NHC 12, first of all.
Yes.
And this, I'll give you a moment to pull it up.
Yes.
And these are emails between the team leader, the development manager, and the councillor, and it's James Gran. We see the first email is James Gran, 12th of January. And there's quite a lengthy email chain that I'll invite the inspector to read in his own time. I'm sure he's read it already. And if you come down to, sorry, it's about the 4th page.
Yes.
There's an email from James Gran to Mr. Curling.
The date of that letter, please.
So it's the 15th of December at 11:30. And it's in response to emails from the council saying that they're going to serve an enforcement notice, and following on from some correspondence to Mr. Gran saying it's frustrating that this is being done just before Christmas.
Yes.
And so Mr. Gran says, why can't we just shortly make a planning application in the spirit of keeping a dialogue open and working with business to avoid enforcement? Now, these emails, do you consider this to be evidence of you engaging with the council?
Of course, fully.
And I can just take you to one other, and it's NHC 9.
Yes.
And again, encourage the inspector to reread this email chain in full, but it starts off as an email chain between Mr. Curlin and your son. And then we come to the first email in the section. Sorry, I've just managed to. Which is the 9th of December 2025.
Yes.
And here you have Mr. Gran emailing Mr. Curling to say, I feel the best way forward is, instead of serving an enforcement notice, the owners make a planning application for the retention of the current hotel model. And we
Yes.
can agree how to describe this, of course, between us all. And then he goes on to say, otherwise, we would need to appeal the enforcement notice, likely on the grounds that planning permission is sought for an alleged development. Now, at that time, Mr. Gran is obviously advancing a case for a hotel model. By way of enforcement, what were you expecting to come at that time?
To come to get into dialogue and come up with an understanding that fits in within the council's remit and the model that we were running.
And so at that stage, were you still instructing Mr. Grant to pursue an application in respect of a hotel rather than flats?
We were instructing to to that flat at that stage. I mean, as you can see, the flat at that stage was either was never our intention. Our intention was for us to use the premises as hotel apartment and legitimize or agree a terminology or whatever you want to call it to legalize it. It's a better word. Legalize the use, which there are various use that the council could have taken. Which Mr. Grant suggested to the council, but they were not engaging.
Thank you. And this goes back to, you were taken to the letter you sent to Councillor Muir. I'm not going to take you to that because this is my last point. Now, in that letter, you complain about the council not being willing to work with you to regularise.
Yes.
And you referred to your earlier hotel, the Templars.
Yes.
Is that what this email is? An attempt to regularise?
Regularise it, exactly.
Thank you. Sir, that completes any questions I have.
Thank you, Mr. Bell. Thank you, Mrs. Sabai. You can sit down now. Thank you. Okay, it's 1:15. So I think it's best we break for lunch. Obviously, we're a bit behind schedule at the moment. How long, bearing in mind we're a bit behind, what do you think is appropriate?
I tend not to eat at lunchtime during inquiries, I have to say, so I'm probably not the right person to ask.
45 minutes?
Yeah, certainly won't want any more. Yeah, is that convenient for everybody? Okay, so we'll have 45 minutes for lunch, so we'll resume at 2 o'clock. Okay, inquiry is adjourned. Thank you.